Thank you. Counsel for the respondents, I just want to make sure that I pronounce your surname correctly. Is it Moncho Moloisane? Let me repeat. Counsel for the respondents, lead counsel. I want to make sure that I pronounce your surname correctly. Is it Moncho Moloisane?
That is correct, Chief Justice.
Okay, all right. Okay, all right. Now, you were not present at the time when counsel was supposed to meet me virtually to talk to me and greet me before the hearing that took place or was supposed to take place at 22:10. What happened?
I think, Chief Justice, there must have been some miscommunication.
Miscommunication about what?
I did, it skipped my mind, to be honest. I need to be honest. But you were.
Sorry?
I apologize for the interruption, my Chief Justice.
Yes. What happened? What was the miscommunication about?
As I said before, I must be honest to say, I did see the correspondence yesterday that we had to introduce ourselves beforehand. But as we were busy starting with the preparation this morning, although we have already prepared, but as we were going through, it completely slipped my mind, and I apologize on behalf of my seniors as well.
So the reason why you were not there is because you were still preparing for the hearing that you forgot.
Not necessarily preparing. Let me say we're just arranging our papers, but as for the substantive issues, the subject matter, we had already prepared, Chief Justice.
So what made you forget such a basic thing? I certainly have no recollection that you have ever appeared before me. Even those who have appeared many times, they know that in this court, they would start by coming to meet the presiding judge before the actual hearing. Before I became Chief Justice, as Deputy Chief Justice, I presided in a number of matters from 2017, and every time by 9:30, counsel would be at court, ready to meet me. There may have been 1 or 2 times when somebody came at 25:02 or something, but there was never an occasion when counsel who is supposed to appear doesn't appear come in time and only arrives at 10 o'clock at court. That has never been. All the matters in which I presided in this court, I don't know about other colleagues. I think there would only be one, Justice Mandanga, who has presided, but I've never heard of that.
Well,
that is completely unacceptable. and the reason you give is unacceptable. It should never happen again.
Thank you. I apologize for that. I have also appeared in the Constitutional Court on previous occasions, and I am quite aware that counsel have to introduce themselves prior to the commencement of proceedings. I apologize profusely, Chief Justice.
Are you familiar with the recent directions that were issued that relate to the hearing since this term, that talk about counsel being restricted to 30 minutes of address without interruption?
I am aware, Chief Justice.
Okay, all right. Thank you. I will now give Mr. Snickers the opportunity for 30 minutes. He told me it would be 28 minutes exactly. And Mr. Snickers, your 30 minutes starts now.
Thank you, Chief Justice. I have it as 12 minutes past 10. In January 2020, the Northwest MEC for Economic Development, Environment, Conservation and Tourism promulgated regulations that replaced the governing gambling levies on gaming industry participants in the province, substantially increasing the levies payable by casinos. The applicant casinos and Casino Association challenged these amendment regulations in the High Court on review. The challenge was based on 3 levels. First, the empowering provisions in the Northwest Gambling Act were unconstitutional, as they provided for the MEC to impose a tax, something the Constitution reserved for the legislature. And they unconstitutionally conferred plenary powers on the MEC and excessively unfettered discretionary powers. Second, even if the empowering provisions themselves could be read down as not providing for an unconstitutional tax, the amendment regulations for their part purported to levy an unconstitutional tax and must be declared unconstitutional. Thirdly, there were also several traditional review grounds aimed at the amendment regulations themselves, independently of these constitutional invalidity challenges. The casinos that paid the increased levies under protest pending their challenge, as to fail to do so exposed them to criminal and regulatory sanction. In the High Court, they asked that if their review be upheld, they should, as appropriate relief, be paid back the difference between the old levies and the increased levies that they paid. In argument before the High Court, the MEC conceded that one of the traditional review grounds was unanswerable, namely that a mandatory requirement of the empowering legislation had in any event not been complied with, that the Treasury MEC should concur in the increase of the levies in question. The MEC persisted only with some technical points in limine relating to authority to bring proceedings and the like, but conceded the review had to succeed if these points were dismissed. The High Court found, on the merits of the constitutional arguments, that the constitutional points on the delegation of plenary power, that's the Justice Alliance point, and on excessively unfettered discretionary powers, the Daywood point, were good, citing the relevant authorities in this regard. It also, however, found that it was this point that had been conceded by the MEC, and that the MEC had been wise to concede it. In this, the court was mistaken. The MEC concession did not relate to the plenary power delegation issue, but to the review ground relating to the absence of any delegation to the head of department to concur in the increases. The High Court accordingly found both the amendment regulations and the relevant empowering provisions unconstitutional, and found it unnecessary to consider the other points of challenge raised by the casinos. The empowering provisions being matters of provincial statute, the declaration of invalidity must be confirmed by this court for it to take effect. The casinos submit that the orders of constitutional invalidity should be confirmed with respect to the empowering provisions, and that this means the ancillary orders, including the repayment relief, should follow as appropriate effective relief in the circumstances. But the ancillary orders are also on the authority of Gorey and Culver and Daywood, before this court, along with the orders that fall to be confirmed. If the declarations of constitutional invalidity of the empowering provisions are not confirmed, the court should nevertheless confirm the orders setting aside the amendment regulations and directing the consequential repayment relief. The reason for this is either that the taxing overreach occurs at the level of the amendment regulations, if not at the level of the empowering provisions, or if the court does not agree that the levies constitute a tax on the Shuttleworth test, the amendment regulations in any event cannot stand in light of at least the unanswerable review ground properly conceded in fact and in law by the MEC in the court below, relating to the wrong official having concurred without any delegation to have done so. The other review grounds also have manifest merit, and this court is in as good a position as the court below to uphold them to the extent necessary in light of the unanswerable point. The rest of my half-hour address will be structured as follows. I will first address the main constitutional point on the nature of the levies as an unconstitutional tax on the Shuttleworth test, either at the level of the empowering provisions or at the level of the amended regulations. I shall not in my 30-minute address add to the Justice Alliance and Daywood points. I refer the court to our heads, paragraphs 52 to 60, and the judgment a quo on this argument, which is independently cogent. I add only to this the not insignificant submission in the MEC answering affidavit in these confirmation proceedings that the levying powers conferred on the MEC, and I quote, uniquely wide powers, unquote. That's from paragraph 7.6.7.10, volume 11, page 816 to 817. I shall then consider the unanswerable and conceded review ground of the wrong official, and only very briefly emphasize only the main points of the other review grounds, and then deal with the appropriateness of the repayment relief as effective relief in the circumstances. I will move on to address the point raised by the MEC on delay as precluding the challenges, and then address the contentions on suspension on the appropriate framing of the workings of the declaration of invalidity. First, on the unconstitutional tax point, that is addressed in our heads, paragraphs 27 to 50, page 10 to 18. The premise of this argument is that the levies in question are a tax, not a regulatory charge, on the test enunciated in Shuttleworth, namely that their primary dominant purpose is to raise revenue for the province, not to regulate conduct. Shuttleworth dealt with legislation and executive action at the national level, whereas here the issue arises at provincial level. The principle is the same. At issue are both the constitutional principle of no taxation without representation that requires taxes to be imposed by democratically elected legislatures subject to legislative debates, and the specific constitutional provisions that confine taxing powers to the provincial legislature, in this case section 228, read with section 120 of the Constitution. It's important to distinguish the two levels at which this challenge falls to be considered. The first level, and this is the principal submission, is that the empowering provisions of the Northwest Gambling Act, that's sections 84.1e, 87.1, and 87.3, necessarily empower the levies as the raising of revenue, i.e. that the Shuttleworth taxing purpose inheres in the empowering provisions themselves. If this is so, then the amendment regulations fall to be set aside because their empowering provisions are unconstitutional. The alternative submission is that if the empowering provisions are reasonably capable of being read down as not necessarily authorizing a Shuttleworth tax, then the purpose of the amendment regulations makes it clear that their purpose is revenue raising, and then the amendment regulations fall to be set aside as a tax, even if the empowering provisions remain extant. As for the empowering provisions themselves, then, there is both textual support in the Act and support in the papers on what is said about the purpose in the papers, for the dominant purpose being the raising of revenue for the province as a whole. The main factors are set out in our heads in paragraph 47 on page 17. First, the preamble of the Act refers to gambling as an important source of revenue for the province. Section 87.1 says that these levies are to be paid at intervals to be prescribed. They are therefore periodically levied and not in any way linked to conduct. They are paid to the Provincial Revenue Fund. That's the central fiscus of the province. Also, it is a debt to the Provincial Revenue Fund, not to the board. Under section 21, the board is funded by transfers from the department, not out of these levies. That's a critical point. There is no provision linking the transfers from the department to the board in any way to the levies inhering to the benefit of the provincial revenue fund. There's no link or connection provided for at all in relation to that. Then textually, although one makes allowance for labels not necessarily being decisive, as was also confirmed in Shuttleworth, section 87(1)(f refers to taxes imposed in terms of this section. And the only thing that is imposed in terms of this section are these levies. That's in 1A to E. And so the provision refers to them as taxes. Section 89 refers in terms to these as a tax, saying gambling levy or similar tax. Now, before I get on to Shuttleworth, it is important, and in our submission decisive, that in the certification judgment, and we refer to this in paragraph 34 of our heads, paragraph 442, this court held that gambling taxes are included in the province's general taxing powers under new text 228. So it is unnecessary to redo the Shuttleworth test because it's already been identified that gambling taxes are a legislative competence under 228. It's important to recognize that here on the papers, both in the court below and in the confirmation proceedings, the dominant purpose is not disputed. There's no contrary purpose set up or sought to be substantiated by the MEC. This is because the only argument on the tax issue presented by the MEC is an interpretation of the definition of provincial tax in the Process Act, something I'd consider shortly. In paragraph 101 of the founding affidavit, this is volume 1, page 47 to 48, the following allegation is made, quote, "The dominant purpose of section 84(1)(e), read with 87(3) and 87(1)(a), is the raising of revenue for the provincial revenue fund rather than to regulate conduct." And then the factors I've already mentioned are listed. Also in paragraph 102, page 49, volume 1, quote, "It is thus apparent that the gambling levies contemplated in the Act are not aimed at funding the operations of the board. They are rather aimed at more generally raising revenue for the provincial fiscus." The answering affidavit in paragraph 17, volume 7, page 520. Having said that the grounds of review are matters for legal argument, the deponent says merely, quote, "The first to third respondents specifically deny that there is any merit in the grounds of review as set out in paragraph 97 to 150. That includes these paragraphs on page 37 to 59 of the founding affidavit. That is it. So in other words, from a specific direct answer to that purpose, there is no dispute or denial. In addition, the answering affidavit filed in this court in the confirmation proceedings only supports and provides no contrary contention at all the main general revenue raising dominant purpose of the levies, particularly in paragraph 20.2, that's volume 11, page 835, and paragraph 7.30.4, page 826, talking about the purpose to generate revenue, to create employment, and better the lives of the citizens of the province. This is also repeated in the heads, paragraphs 45 and 55. If one looks at the case law considered in Shuttleworth and the exit levy in Shuttleworth itself, there are some very critical distinguishing and defining features. The exit levy was specifically aimed at incentivizing conduct, having a behavioral effect to deter outflows of capital, and it was closely linked to the specific conduct being regulated. The conduct determined the amount of the levy. It was an important part of the state argument that the state cannot know in advance how many persons would apply for exit levies and cannot budget as it would for a general tax. Here, one is effectively dealing, here in our case, one is effectively dealing with the type of special income tax levied on the gaming industry, periodic monthly payments of a percentage of gross gaming revenue. Also, one should distinguish cases such as the Maize Board and EPOL, referred to in the Shuttleworth judgment. The levies in that case went to the board and were specifically earmarked for the schemes administered by the board and certain specific earmarked projects. They did not go into the general fiscal pot for the benefit of all. And in the West Dunes Supreme Court of Appeal case, which we referred to our heads footnote 33, There was a distinction drawn between a specific endowment earmarked for defraying the expenditure to be incurred in relation to a particular activity sought to be embarked upon, that case the development of townships, the permanent estate case, when it would not be a tax, from rates levied to pay for general services rendered as a whole, which is a tax. That's in paragraph 27. Here, the latter is undeniably the case rather than the former. As for the purpose in the amendment regulations themselves, if the court were unable to find that the dominant revenue-raising purpose in the empowering provisions exists there, then the amendment regulations themselves on the facts are clearly prompted predominantly by a revenue-raising purpose. This is set out in the heads, paragraphs 91 to 96, pages 32 to 4, in the finding affidavit, paragraph 109, 51 to 53 in volume 1. Number one, the levies far exceed the amounts made available to the board. Most of the levies are used for purposes unrelated to the board, so that's important. The National Gambling Board has stated that gambling levies are used for general expenditure, infrastructure, schools, service delivery, etc. That's in their annual report, which one finds in volume 5, page 337. The only specific purpose motivated to any MEC by the board for the increase in levies, that was to MEC Nelson in November 2018, spoke of the purposes of revenue raising and service delivery by the province. That is SFA 9, page 446 to 447 in volume 6. And then there is no suggestion anywhere in the papers of a behavioral purpose to incentivize or disincentivize any conduct of any kind. All licensees are levied equally on a progressive basis based on revenue, very much like an income tax, and it's paid periodically. Again, the answering affidavit does not take issue with these purposes and facts set out at all. The same paragraph 17 that I've referred to above, which is in volume 7, page 520, which denies about 60 paragraphs have any merits in the review, responds to this paragraph 109. Now, the reason for this is that the only argument raised by the MEC against the tax characterization is a complete misreading of the definition of provincial tax in the Process Act, as by definition being a tax imposed by national legislation. That one finds in the confirmation answering affidavit, paragraph 4.8, volume 11, page 806. This is an obvious misreading of the definition, which tracks section 228 of the Constitution. Section 228 of the Constitution envisages a provincial legislature may impose two forms of provincial taxes: taxes, levies, and duties. That's that it imposes itself, the provincial legislature, its base taxes, 2281A, and then flat rate surcharges on taxes, levies, or duties imposed by national legislation. That's in B. The same dichotomy is mirrored in the Process Act, which expressly cross-refers to section 228 of the Constitution and defines a provincial tax as, quote, a tax, levy, or duty, or a flat rate surcharge on the tax base of a tax, levy, or duty that is imposed by national legislation, which a province may impose in terms of section 228 of the Constitution, i.e. either the province's own tax, levies, or duty imposed by its legislature, or the surcharges that it imposes on taxes imposed by national legislature. Obviously, it cannot with respect be otherwise, as the Process Act, after all, regulates when and how provincial legislature, rather than a national legislature, can impose a tax. For reasons mentioned then, the declaration of constitutional invalidity falls to be confirmed. Or, if not, the order setting aside the amendment regulations must stand, as the amendment regulations themselves impose an unconstitutional tax. I now proceed to deal with the reason why, even if the above submissions are rejected, the ancillary orders nevertheless should stand. The setting aside of the amendment regulations and the repayment relief are these ancillary orders, based on the merits of the review that served before the High Court, and in particular, the conceded existence of an unanswerable decisive ground of review. So this unanswerable decisive ground of review, this is the concurrence of the MEC that didn't occur, that we deal with in our heads at paragraphs 97 to 103, page 34 to 36. The point is rather simple. Section 87.3 of the Act requires the Treasury MEC to concur in the gambling levies raised by the MEC for economic development. On the papers, it's common cause this didn't happen, but that instead the head of department provided the purported concurrence. It is important that it is not alleged that the head of department was communicating the Treasury MEC's concurrence, but rather that the head of department concurred as he was delegated to do so. This one finds in the answering affidavit of the court ar quo, paragraph 12.3.13, page 501, volume 7. The delegation relied on, however, was of the accounting officer powers under the PFMA. That's volume 7, page 528 to 9 is where that delegation occurs. It had nothing to do with concurring power under section 87.3 of the of the Northwest Gambling Act. And as correctly conceded by the MEC in the High Court, there was no provision in the Northwest Gambling Act for the ability of that concurring power to be delegated, unlike the PFMA powers. The MEC correctly conceded that this was unanswerable. The concession was not the concession that the High Court or the MEC in its heads attribute to the MEC Council. That concession was not the one that was made on the plenary powers point. The concession that was actually made on the absence of the proper concurrence and the wrong delegation in that regard was not a purely legal concession. That's important to emphasize. It's at least partly a factual one. There was no MEC concurrence. No delegation of the section 83 power had in fact occurred to the head of department. And then the legal point that there is no power to delegate to the head of department. The brief highlights on the merits of the other reviews. I'll name only two. First, the irrationality and arbitrariness of the amended regulations. These one finds particularly dealt with in our heads in paragraphs 111 to 120, page 38 to 41. There is the central invocation of inflation. And the point is a very simple one, which is that inflation cannot justify an increase in rates, only at best an increase in thresholds. 8% of something that increases with inflation increases with inflation. Contradiction in logic, one then finds on the thresholds themselves. One looks at the motivation document in volume 4, page 246. There's this notion that the threshold should have been close to 7 million, but it was made 6 million due to the sluggish performance of the casinos. But of course, lowering the threshold means that the levy that gets paid is a higher levy rather than a lower one. And then there's the complete arbitrariness in the levels of increases and the thresholds and the rates and the relationship between them. There is nothing underpinning this at all. This is dealt with in the heads, paragraphs 119 to 120. There was never any explanation given for how this is made up. And the Bertie van Sale decision is cited as an a fortiori application here. The next point is the rubber stamping and no application of mind by the MEC. That we deal with in our heads in paragraph 121 to 132. The point is rather complicated, but the best illustration is that the MEC Mosenogi, who was the MEC who actually promulgated the amendment regulations and therefore made the decision in question, in a letter to the Treasury MEC on 23 September 2019, this one finds in volume 6, page 429 to 432, said she believed her predecessors had already taken this decision and had based this decision that the predecessors had taken on the rationales given in the motivation document. But this rationale in the motivation document did not serve before the predecessors, Nelson and Matsamela, but they were created after they'd left office and had incorporated the same reasons verbatim as had in an internal board memorandum motivated a flat rate of 8.5% rather than the specific increases at issue. So the strength of the review therefore serves as a just basis for not interfering with the ancillary orders, setting aside the amendment regulation and directing the repayment relief, even if the court would decline to accept the constitutional arguments on tax. As for the appropriateness of the repayment relief, this is dealt with in the heads, paragraph 71 to 81. This is on all fours with Shuttleworth in this regard, and the Supreme Court of Appeal treatment was not upset by the appeal because the appeal found against the unconstitutionality and therefore didn't go into the remedy question. A payment of a wrongly levied tax under protest on pain of criminal and regulatory sanction founds a condictio in debiti. This can also be seen as appropriate relief under section 172 as part of the corrective principle on all pay and under section 8 of Paja. It's critical for the justness of the repayment relief to appreciate that it was expressly conceded in the heads in the High Court that if the amendment regulations fall to be set aside for whatever reason, then the repayment relief must follow. There was nothing in the papers filed by the MEC in the High Court in answer for why this is not a just consequence. I don't want to deal with the major point in the answering affidavit and in the MEC heads in this court, which is the delay point. There are two aspects to the delay point, and they can be dealt with very quickly. The first is that the challenge to the empowering provisions is in some way out of time. And the second is that the challenge to the amendment regulations is out of time because the original regulations ought to have been challenged some time ago. Now, neither point has any merit. As for the substantive challenge to the legislation, I can refer simply to the distinction drawn by a unanimous court in the President and Quagliani matter, 2009, 4 SA 466, paragraph 30, where procedural challenges to legislative process, particularly in the Doctors for Life kind of pre-act scenario, can be barred by delay. But that was distinguished from, quote, the ever-present right to challenge the constitutional consistency of the resultant law. As for the point that one can't challenge an amending regulation, that, as this one does, expressly replaces the previous version without having attacked the previous version, there is no authority for this proposition. Two examples clearly put paid to this. Shuttleworth itself. In Shuttleworth, the minister announced an exit levy in his speech in 2003. The Reserve Bank applied it as a policy, and this was applied against Shuttleworth in 2008, so 5 years later. He paid the levy without protest in 2008. Then on another export in 2009, the levy was again applied against him, and he now paid under protest and challenged it as a tax, including the empowering provisions. There was no suggestion in the SCA or in this court that he was precluded by delay in either respect. And then in the Security Industry Alliance and Private Security Industry Regulatory Authority case, 2015, 1 SA 169, Supreme Court of Appeal. Because it's so much in point, the point is rather trite, but this one is so much in point. There was also an amendment to levies payable by regulation, and that amendment was challenged. The original regulations were in 1990, and the amendment in 2011. And there was no suggestion one couldn't challenge the amendment without having to have challenged the original regulations. Finally, the point on suspension raised in this court, suspension sought for any orders of invalidity. The first point to make is that there is no basis put forward to support this in fact. The factors set out in the mystery decision on why suspension should be appropriate are not addressed at all, and mystery makes it clear it's a true evidential onus. The starting point is effective relief for the applicants. That is the principle from Fosse and from J versus DG of Home Affairs, 2003, 5 SA, 621 CC. The litigant must be afforded effective relief. Suspension in this case would not be effective release for the applicant. One must balance the effective relief with the effect that the regulations falling away with the empowering provisions may have. We say that this is easily remedied. Instead of a suspension, which is a sledgehammer, the court can direct for limited retrospective invalidity of the empowering provisions from the date of the amendment regulations. That's 23 January 2020. That would mean, that would have the effect on Seal and Kurland and the like, that the previous regulations would remain extant. Nobody has challenged them, and they would remain in place to govern until a tax is actually imposed by the legislature itself, as it ought to. Of course, this issue arises only if the empowering provisions are declared invalid, not if only the amendment regulations are declared invalid, because whether on the tax argument or because of the unanswerable review point, because in that case, the previous regulations continue to govern. Chief Justice, that is the 27-ish, 8-ish minutes that I had promised. Sorry, Chief Justice, you're on mute.
Thank you. No, I'm saying thank you very much. That was even earlier than the 28 minutes you had expected to take. Thank you very much. Can everybody hear me? Oh, I'm sorry. I may have been muted when I thought I had unmuted myself. But I said, thank you very much to Mr. Sneakers. He did even better than the 28 minutes he had hoped to take. So thank you very much. Colleagues who may have questions for Mr. Sneakers, you may go ahead and I'll put questions to him if there are any.
Mr. Sneakers, if I may, thank you, CJ. In your heads, you didn't deal with this in oral argument, but in your heads, you make the point that, or you submit that regulation making as we have here is administrative action. As I read the authorities, this court left it open and you clicks. There was no clear majority. Other courts subsequently thought that the Shaskelson CJ decision, dictum or judgment in that case presented authority for the stance that this is administrative action. Well, as Mostert nominee Fike in the SCA said in 2017 later, and which I think is correct in my view, there was no clear majority and there's no authority from Shaskelson CJ anyway that that this is administrative action. I think the question was left open. If we do get there, can you expand on that submission that this is administrative action? It seems to me that the matter hasn't been finally decided, and at least not by this court.
Yes, thank you, Justice Majid. I have to answer that by saying that nobody can deny that it is a perplexingly perennial, unsettled question. Everybody has put forward ways of saying when do regulations amount to paja and when do they not, instead of simply accepting that they always do. The nature of the power and whether it affects particular parties in a way that it doesn't affect other parties, the extent to which it is narrow as opposed to wide, all those things go into the question whether it is administrative action or not. I may make the bold submission that it is time for this court to pronounce that regulation, subordinate legislation is always paja administrative action, that there is sufficient in the case law, particularly in cases like ESA, to support that proposition, and the cases to which Justice Majid, you have referred in interpreting the decision. And it's time to do so. I may, however, say that in this case, it doesn't matter. It normally matters when a paja ground of review, particularly reasonableness, would be critical, and where one cannot squeeze that ground of review into a legality challenge. What has happened over the years is that what one can squeeze in under a legality challenge has become bigger and bigger, making it less and less important whether you're able to categorize something as paja or not. But the fact remains that all the challenges in the review and the constitutionality challenges that are at issue here are challenges that would be cogent whether it's a legality challenge or whether it is a paja challenge. There is no single challenge that depends for its cogency on the categorization of paja or not. And again, I may say that you often get that submission, and that is then often a reason not finally to pronounce on the question which I invite the court with great respect to pronounce on, that regulation is paja, yes. And that then that is the certain.
Just one further aspect, I may just add that commentators, particularly administrative law authors, leading authors, accuse this court of too easily resorting to the legality challenges instead of meeting matters head on, and it should be paja challenge. But that's an issue for another day. Can I just ask you, there seems to be an attempt by counsel now representing the respondent, to veer away from the concession made in the High Court. They say that that concession was wrongly made, and because it's a concession in law, that concession does not preclude this court from filing differently. I understand that you submit that it's at least partly factually, but what do you say about that attempted withdrawal of that concession by previous counsel for the respondents?
Yes, Justice Majid. The problem is that the situation can only be described as bizarre, and I don't do that flippantly. The concession that was actually made, and we set this out at paragraph 67 of our founding affidavit and with reference to the extracts from the transcript. The concession that was actually made was a concession relating to the unanswerable review ground for the concurrence under section 87.3, that there was no delegation of that concurrence power. That was the concession that was actually made. It was abundantly clear in the hearing, as appeared from the transcript, that at the time of the hearing, that was appreciated. That's the concession that was made. So what the MEC said was, because I'm conceding this, because this review is good, don't go to the constitutional issues, don't go to the Act, don't go to the regulations. The review is good, but I have points in limine. So I'm not just giving up. I have my points in limine. But if my points in limine are dismissed, then the review should succeed. And the points in limine, with great respect, we have referred to them only if necessary. They are these authority points and things that don't go on Rule 7 and so on, that one shouldn't waste too much time. What then happens is that in the judgment, the judge considers the constitutional points on plenary power and delegation of powers that are unfettered, and considers that on the merits. So it's not just saying it was a conceded and I say there was a good concession, and then says that was a concession that was made by counsel for the MEC, this delegation issue, and that was a wise concession. That, with respect, is unfortunate, because that means that the court then didn't uphold the review on the point that the MEC had conceded. We come to this court saying, well, this had happened. We need to confirm. The confirmation's good, the concession's good, but if the confirmation is not given, it would, with great respect, be a crying injustice not to have that review relief upheld in any event, not just because there was a concession, but it was a good concession. The answering affidavit that then comes in doesn't, for some reason best known to the answering affidavit, address our story about the wrong concession. It simply refers to the judgment which relies on the wrong concession and says this is a concession that was wrongly made.
Sorry, can you help me, Mr. Sneakers, can you just help me? Where in the answering affidavit do they deal with that aspect? If it's a problem getting it now, you can always come to it back later. But
no, there are two. I had the reference. There's paragraph 67 of our founding affidavit.
Yes.
In these proceedings, have you got the reference, Mike? Ours, paragraph 67. I'll just get in the heads. That's probably the best place to find all of that.
698.
698. I'll just, sorry? Volume 10, 698.
Yes, I've got it. Thanks.
That's paragraph 67, which sets out the concession that was actually made and refers to the transcript and so on. The answer to that paragraph in the answering affidavit is one of these rolled up answers, add 20 or 30 paragraphs that says the review grounds have no merit. And I say what I've said above about tax. Earlier in the answering affidavit, and I can get that reference for the court, earlier in the answering affidavit, there is a reference to the concession that was wrongly made. And that reference cites the judgment only. So by the time they get to deal with what we say the actual concession was, for reasons I really don't understand, with great respect, it's not addressed. They don't say, no, you were wrong, we were right, the judge was right, or anything like that. We had actually invited them in that paragraph 67. We said, we are sure that this will be made common cause, that the only reason the judge did not find on the review ground in our favor on basis of their concession was because she misunderstood the concession that was made when it came to writing the judgment. and that, with respect, is not answered. So that's a very long answer to the question. But then the answer to the nub of the question, answer to the nub of the question, though, is that the debate they're having on a legal concession is the wrong debate, because it's the wrong concession. I've got the reference from my junior, answering affidavit, paragraph 7.15, page 819, volume 11. So the concession that they say was made, and that it was a legal concession, that's irrelevant. But even as the judge understood it, assuming that was the concession that was made, and assuming it was a legal concession, it's clear from the judgment that the judge went on the merits. There's quite a lot of law in there that was submitted to the judge on the plenary powers issue and the Daywood issue, the Justice Alliance cases, the Daywood cases, Van Rensburg, etc. And then she says this was wisely conceded by counsel for the MEC. So it was simply a fact of saying it was a wise concession. When it comes to the concession that was actually made, it is true, subject to some quibble that I might not go into, but it is true that generally a legal concession doesn't bind, and I wouldn't say a legal concession should be binding at the appellate level in this court. But the concession in relation to the delegation issue was not a purely legal concession, because the concession in relation to the delegation issue was there was no delegation as such. It had not occurred. And also that the MEC had not made that decision. So there was no attempt opportunistically to argue and to say, although this letter is written by the HOD, it's actually a decision that was made by the MEC, and that's now being communicated. That was not the case presented in the papers or in the court. In the papers, the case is it's the HOD who made the decision, but he was properly delegated to do so. Have a look at this delegation. One has a look at the delegation, one sees it's PFMA delegation. It's got nothing to do with 87.3.
Yes,
so that
you.
then, thank you.
Thank
Yes, Justice Major.
Mr. Snickers.
Yes.
Okay, Justice Rogers first.
Yes, Mr. Snickers, I just wanted to ask this. It may not matter, but was the point of delay raised in the High Court? I don't see it in the answering affidavit in the High Court. Perhaps the basis on which the High Court decided the case meant that it didn't need to consider delay.
I can put it in this way, Justice Rogers. We originally were indignant about the delay point being raised for the first time here, until I had a look at what we looked at in the court below, and it is there. It is raised, albeit very obliquely, in the court below. It was not raised in argument. It didn't form part of the argument before the High Court, which was probably why I was under the impression it wasn't there. But it's raised. It's raised in the proceedings ar quo in the papers. It's not by any means it's given the prominence that it's given now. But I can't say to you it's a new point with respect.
Perhaps in reply, you can just give us the reference in the answering affidavit where the point is made.
I can have my junior look for it.
Thank you.
It may have been in the original. Yes, I'll ask my junior to have a look at that.
And then maybe also when you respond to that in due course, you could also indicate what the applicant's response to it was in the reply.
Yes.
Yes. Thank you. Justice Theron.
Thank you, Chief Justice. Mr. Snickers, if we get to the PAJA legality review, this court would be sitting as a court of first instance in that respect. Is that right?
It would, Justice Theron.
Why should we sit as a court of first instance, or as opposed to sending the matter back to the High Court? What would your submissions be on that?
Yes, Justice Theron, in this case, you have the fact that the ancillary order, which is the order to set aside the regulation, is also before the court on the authority of Garion Culver and Daywood. So that issue is in fact before the court because it has to be decided on the basis whether the ancillary order should stand quite apart from whether confirmation is granted or not. So the first answer, it is before the court. To answer the question of the undesirability of acting as a court of first and last instance in relation to a particular point, it occurs in all cases where a matter is decided and certain issues are rendered obiter, and those issues then don't have the benefit, the court on appeal doesn't have the benefit of those issues, reasoning on those issues of the court below. So it in itself is not decisively fatal to the desirability of hearing it. But in this particular case, where there was this conceded unanswerable ground, and in the absolutely extraordinary circumstances that one has here, which is that we challenge on various grounds, before the High Court, we get surrender on the review ground, apart from the points in limine. So we get surrender on the review ground. So we get told, and the judge gets told, the review ground's so good, don't worry about the constitutional issues. This is now from the respondent side. Which means that if the judge had simply found on that basis, A, we wouldn't have been here, and B, the review ground would have been upheld. One then gets the confirmation of constitutional invalidity coming to this court, with the review ground then having been rendered unnecessary. And then one gets the argument from the respondent, but hang on, send us back to that review, to have that review decided. With great respect, in the circumstances, that can never be just. And then the review ground that was conceded is simple and is unanswerable. So in that situation, even if one doesn't look at the other review grounds, which I submit with respect are as strong as that ground, but they hadn't themselves all been conceded. So in that situation, the court is there isn't going to be any benefit to this court of the kind that one gets from a consideration of the record and whether certain things were done and discretionary decisions made and the like, and a court or code dealing with a particular review point. The court is in as good a position as the court or quo would have been. It's not going to get into a better position on appeal. And the matter has been delayed. The judgment was delayed for a considerable period of time. And it would, in the circumstances, therefore, be one of those cases where a remittal with great respect would neither be just nor sensible.
Before I follow up with my next question, Chief Justice, Justice Makhoka is no longer with us.
Oh, has that been for some time? Do you know?
I think he was having connectivity problems a little earlier, but he was still on the screen. But I think he's disappeared in the last few minutes.
Okay, I'm sure Mr. Naidu is busy trying to reconnect him. Thank you. Okay, we may proceed. I'm sure he will join us.
Yes.
Were you done? Justice?
I would like to continue with your leave, Chief Justice. Thank you. So if I understand you, Mr. Sneakers, you're saying the exceptional circumstances and it's the conduct of the respondent that has also placed us in the position where if we get to the review ground, that the PAJA or legality review, this court would be sitting as a court of first instance.
Yes, and that those considerations that tend to render that undesirable in the majority of cases don't apply in this case.
Yes. If I could just go to the relief that the applicants are seeking. Now, part of your argument for the repayment relief is that it flows from the operation of the doctrine of objective constitutional invalidity, and that there was never valid legislative authority in the first place for imposing the levies. You don't ask for all the levies collected in terms of those regulations. Now, what is the distinction between the period until the amendment and the period after the amendment for the purposes of the repayment relief?
Yes, thank you, Justice Theron. The question is tied in a way to this issue of what's being challenged. And it's tied to the Kurland and Seal and Odekral doctrines. And it's the following, that the objective validity, if one wants to call it that or not, of the regulations does not make them disappear from a legal effect point of view unless and until they get set aside. What we challenged is only the amendment regulations. And if the amendment regulations get set aside, then only the difference needs to be paid because the original regulations would remain. The complication comes in if the empowering provision is struck down, because if the empowering provision is struck down, sorry, before I get there, there's never been a doctrine that whatever other laws may also be unlawful because of the logic of your argument must also fall. That's never been the law. And that therefore means that even if the logic would also apply to something that wasn't challenged, that doesn't make that disappear as a reality in law. The complication comes in with the setting aside of the empowering provisions. If one were to set aside the empowering provisions, it would then, it's a difficult question, but it seems as though it would be difficult then to argue that the regulations passed under the empowering provisions can remain extant and regulate because of the judgment in Seal, as confirmed in footnote 74 of the judgment in Kurland, to the effect that although Odekral applies before setting aside of anything to recognize the legal effect of that which may be unlawful but hasn't yet been set aside, the moment something is set aside, that which depends upon it for its validity is then also set aside. So that is why it would make perfect sense to, if the empowering provisions are held unconstitutional, as we say they should be, to make that order of constitutional invalidity restrictedly retrospective. In other words, prospective from the 23rd of January 2020, because that would then mean that on the Kurland and Odekral principles, the original or the previous extant regulations will continue to operate. All of that is a long way of answering the nub of the question, which was that how do we get repayment not of everything but only of the difference, and that with respect is how we get there. We didn't challenge and nobody else challenged, and there's no reason to require the challenge of earlier legislation, earlier regulations. There is this, which is a comfort if there's a potential discount, and that is that the repayment relief, the cases referred to in our heads and in Shuttleworth in the Supreme Court of Appeal on this, on payment under protest, would confine those entitled to that kind of relief to those who would have that condictio. And one would not have other such entitlements because nobody paid under protest, and people would be way out of time for challenging anything, which was a point also made in the Shuttleworth decision in the Supreme Court of Appeal. I think it was in paragraph 34 of that judgment, and it's a similar situation.
Thank you, Mr. Sneakers. Thank you, Chief Justice.
Thank you. It looks like Justice Makgoka is back. Are you back, Justice Makgoka? Or is it a frozen picture that I'm seeing? No, it looks like he's not back. We are at 9 minutes past 11. He has been out for some time. I wonder whether it might not be better to rather take the tea break now, even though there may be other colleagues who have questions for Mr. Sneakers. hopefully within the tea break, he would be able to, the technicians would be able to address his problem. So I think let's take the tea break now. It's 10 past now. We are going to be back at 25 at, no, I'm sorry. No, it's 5 past, not 10 past. Yeah, it is 5 past, just not 10 past. It's 5 past. We'll come back at 20 past. We adjourn.
Court will adjourn and Court will adjourn until 20 past 11. Please note that during the adjournment, you are welcome to both video and sound when the hearing recommences at 20 past 11. Should you exit, you may use the same link to read
Um, take it that we are all back. Justice Mahoka, we are aware that you were disconnected for some time. So we took the tea break earlier than normal in the hope that your connection problems would be sorted out. I hope that everything will be fine now. Oh, can anybody hear me?
We can hear you, Chief Justice.
Oh,
Yes,
I thought I can see Justice Mhoga's picture, but I thought I could see his head move as well, but maybe I'm mistaken because he doesn't respond.
He's muted at the moment.
You must just unmute us.
Oh, please unmute yourself, Justice Mhoga. But even when he's unmuted, he would hear me. Did you hear me, Justice Mhoga? Yeah, there's no indication. But if he can't hear me, I wonder whether he can hear other colleagues. Justice Mhoga?
Perhaps he should give a thumbs up if he can at least hear.
Well, his head is moving. Yeah, his head is definitely moving. But it's not even as if he's talking, but we can't hear. He's not talking at all. There is something wrong.
Yeah, I see he's making a phone call now, Chief Justice.
Oh, okay. I'll check my phone. I think we should stand down for 5 minutes. Let me try and talk to him on the phone and hear what the challenge is. Let's adjourn. It should be 5 minutes only. Thank you.
There's the court, please.
Good morning, Justice Makhoka. Can you hear us?
Hi, Steve.
Hello, hello there. We're in the hearing. I'm just going to get.
Can you hear me, Steve?
Yeah.
Hi, Steve.
Hi there. I hear you. I'm just going to ask that the Chief Justice come back. We're still in the hearing. We've just adjourned. So.
Okay, I'm back.
Hello, CJ. Can you hear me?
I can hear you, and you can hear me?
I can, CJ. Yes.
Okay, no, that's all right. Thank you. Is everybody back? Okay, I think everybody's back. Thank you very much. I know that you said that the last you had was when Justice Rogers was putting questions to Mr. Snickers, but I think that you will be able to look at the transcript and see what was exchanged between Justice Ron and Mrs. Snickers during the time that you were disconnected. Justice Makhoka, colleagues told me that he thinks he was disconnected for about 10 minutes by the time we took the tea break. So, okay, all right. Thank you. I think you were done, Justice Theron, with your questions. Let me see if there are any colleagues who have got questions for Mr. Snickers before
Thank you, CJ.
we
Thank
move.
you.
Yes. Okay, Justice Goloban.
Thank you. Mr. Snickers, in the High Court, the primary relief sought by the applicants really related to the amendment of Regulation 73(1). The relief that was sought in respect of the provisions of the Northwest Gambling Act were framed in the terms "to the extent necessary." The High Court, in its judgment, granted that additional relief, but didn't seem to grapple with why it was necessary to do so beyond the primary relief. But in your engagement with my sister Justice Theron, you seem to have dealt with why you thought that was necessary. And it may well be that the relief relative to 84(1)A, which is the what you call the impermissible delegation of authority to the MEC, may be necessary, as well as the relief in 87(3), which is the concurrence, because that would follow from 84(1)A. My question to you is, why would it be necessary to have declared 87(1)A unconstitutional? And I put it in these terms: 87(1)A appears to provide a general obligation of a license holder to pay a gaming levy. I must assume from that, well, and when I read 87(1)A, it doesn't refer to a gaming levy prescribed by the MEC, but a gaming levy. Is it not arguable that by declaring 87(1)A unconstitutional, even if a gaming levy was validly brought into force, the removal of 87(1)A would mean that there's no obligation on a license holder to pay such a gaming levy? So I didn't see the connection between 87(1)A and 84. It creates a general obligation to pay a prescribed gaming levy, and provided the gaming levy is properly prescribed and properly brought into force, I have some difficulty as to why that section must fall as well.
Thank you, Justice Colopin. Can I, just before answering your questions, just revert to an answer that I gave to Justice Rogers on the issue of whether the delay point was raised in the papers or quo. I had made what was a incorrect factual concession in that regard, because the point was raised, but it was raised in heads of argument, and they're not persisted with in oral argument. So the heads of argument are quo were not in the record, and we've gone through the answering affidavit itself, and no doubt that was the reason why Justice Rogers posed the question. In the answering affidavit, in other words, on the papers, the point is not there. The point of delay is not taken. So it's a new point from a pleading point of view, but it's not a new point in that it's raised for the first time in this court, because it was raised in the heads of argument. So the references to the answering affidavit sought and the replying affidavit in that regard, the simple answer is that there aren't any, because the point was not raised at all in the papers, which was why we originally thought it was a new point, but then I saw it had been raised, but I didn't realize it had been raised only in the heads. So that's on that. As far as the question of to the extent necessary is concerned, there are a number of answers there, and if I may just take them one by one. The thinking in relation to what needs to be struck down depends on the question to what extent the empowering provisions necessarily empower a tax with the purpose of Shuttleworth. If they necessarily do so, then the regulations 73.1, sorry, then the regulations simply do what they are empowered to do by unconstitutional empowering provisions, and then there's why one would then have to set aside the unconstitutional empowering provision. To the extent necessary is because there's room for an argument which we submitted would not be a correct argument, but there's room for an argument, or at least a conceivable outcome, that it gets found that the empowering legislation can be read as empowering things that fall short of taxes as understood by Shuttleworth, and then the purpose of the regulation itself makes it clear that the purpose is a tax, and therefore then the regulation itself only fails. So that's for the reason for the extent necessary. When it comes to the finding of the court or quo, with respect, Justice Colopin, that was correct, that because the finding of the court or quo went on the plenary powers and Daywood excessive discretion points, those points are points that in here or relate to the primary empowering provisions and not to the delegated legislation. So if those points are good, then the empowering provisions must fail. The point on the tax, however, may be upheld either for the primary empowering provisions or for the regulations themselves. If one then gets to 87.1, it is correct that 87.1 does not by itself refer to the MEC, but it does refer to prescribed. So in other words, you have a question of prescribed, therefore by regulation. So 87.1 has in it the problem that it provides for the tax to be imposed by something other than the legislature. And 87.1 must be read together with 87.3, which makes it clear that it is the MEC that does so with the concurrence of the Treasury MEC. I think with respect that part of the problem here is that in the amendment of the provision, the provision 87.1 read differently up to 2005. It had only 3 subsections. And those 3 subsections referred to taxes and fees and license fees. Levies, fees and license fees. Then in 2005, it was amended to have this 87.1a to F. And in 1a to E, one is talking only of the levies. But F then suddenly talks about all gambling, levies, taxes, and license fees payable in terms of the provisions of this section, which seems to be a throwback to a section that did something more than simply impose the levy. So that adds to the complexity a bit. And then in 87.3 refers to the levies and fees, and one isn't clear what distinction there is being drawn between levies and fees in 87.3. So The proper answer, therefore, must be that on our submission and our logic, 87.1 must fail because it is contrary to section 228 of the Constitution, whether it is the MEC or somebody else who does the prescription. It's not the legislature. So that's contrary to the provision, to the finding of this court in the certification judgment.
Mr. Snickers, is it your submission then that the legislature cannot prescribe, and therefore prescribe by itself must mean an unconstitutional means? Because if it was arguable that the legislature could prescribe, then does it not run the risk that even if a levy was validly and lawfully brought into existence, the striking down of 87.1a would absolve any license holder from paying such a levy, and one creates an undesirable legal lacuna?
I just make sure of this, Justice Colopin. I think this is one of those where prescribed is defined as prescribed by regulation. Yes, it is. So the definition of prescribed in the Act is prescribed means prescribed by regulation in terms of this Act. So that removes the possibility that that would be the legislature. And the question of the lacuna is if the empowering provisions are struck down as we submit they ought to be, is easily addressed with great respect with the limited retrospectivity up to the date of the amendment regulations, which was 23 January 2020. And that by itself has never been a sufficient reason not to grant effective relief, because and in any event one must bear in mind that the legislature is free to impose a tax as the certification judgment considered. Where does this power lie? Is it in the province? Is it? And in that judgment, the question was, well, it's not specifically provided for. Is that a problem? And it was found, no, it is. This taxing power is there for the provincial legislature. It's in 228 of the Constitution. So they are also not subject to the drag restrictions, if one can call it that, with a bit of loose language that one has in relation to Parliament, the provincial legislatures. They may not move with alacrity, but they can at least move quickly.
Thank you, Mr. Snickers. Thank you, Chief Justice.
Thank you. Mr. Snickers, if the delay point was not taken in the answering affidavit by the respondents, is this a type of point which can be argued, included in argument when it has not been foreshadowed in the papers? In other words, is it permissible to argue when it is not in the papers, in the affidavits?
Chief Justice, with the greatest respect and honestly, I would like to say no, but my honest answer would have to be qualified somewhat, which is that let's assume, and I'm only doing as a thought experiment, that I were to do that, I would do it on the basis that it appears so clearly from what is in the founding papers that there's a delay problem, that there ought to have been a request for an extension under PAJA, etc. So that's not that one wouldn't be able to raise in relation to delay problems relating to the extent to which the previous legislation was the same and all of that. But if it were so that it appeared undeniably from the founding papers that there was prima facie a delay problem, it would probably be open to a respondent to argue and to say that on the founding papers, they don't make out a case for overcoming delay, even though I didn't put this in my answering affidavit. So I take it that is applying the principle of charity. I take it that is what happened in the court a quo, that the point was raised in heads of argument on that basis. That said, however, it's not the kind of point that one doesn't take and take squarely in the papers. It certainly is extraordinary to expect us to address it on confirmation proceedings and then to have an affidavit come in at the time that it did with heads that come in, and half of it is about delay. So that, with respect in these proceedings, does make it entirely inappropriate to entertain that objection, even if it had merit. Fortunately, with great respect, fortunately, it doesn't have merit. So the problem really is a non-problem.
Okay, I think your answer is straddling between two things there, a yes answer and a no answer, but maybe up to a certain point understandable. But isn't this the kind of point that the applicant would need to respond to at a factual level if it was taken in the papers? And if you take it in argument without having taken it in the papers, the applicants then don't have an opportunity of responding to it factually.
Yes, with great respect, I'm indebted to that helping me out of my submission in that regard. But again, all I can say is that conceivably one could argue that if a delay point appeared clearly enough on the papers and there was nothing in the finding affidavit to justify a delay point, one could conceivably argue that that's enough to render the application defective without raising it. But you do raise a point, Chief Justice, that these points are all matters of discretion and of all the facts that are involved in it. And even in such a case, one would have wanted to have had the point raised so that the applicant can say, well, for the following reasons, on the following facts, the point you are raising is not a good point and ought not to be taken by accepted by the court. So on reflection, my submission is that the point could not be considered, and certainly shouldn't be considered in this court, not having been taken squarely in the answering papers.
And then the relief about repayment, I saw a reference to the basis thereof being unjustified enrichment and so on. Wouldn't that be the kind of thing that should be the subject of an action afterwards? I mean, on the face of it, if payments were made under a law or regulation that has been found to be unconstitutional or unlawful or whatever, one can understand why it would be convenient that whatever payments were made under it maybe should be repaid or refunded. But unjustified enrichment is quite something, you know. Shouldn't that be something that should be dealt with by way of action?
Chief Justice Zondo, there are two questions there. The first is it competent / appropriate for that kind of relief to be granted in a review based on the unconstitutionality of the provisions in question? And there is, fortunately, a lot of support for that being the case. Shuttleworth in the Supreme Court of Appeal being not the least of it, but we've cited the examples in our heads of argument, so that it's not a novel idea that this is the way to vindicate it by way of relief granted in a review. And there are three ways in which that can be done. And the first is to say that this is a review, this is appropriate relief under the review, and it is clear that that which has been paid under protest and was unlawfully paid must be repaid unless there are facts put before the court as to why that ought not to be the case. The second is to say that that's in any event a situation where it would be appropriate relief under Section 8 of PAJA. And then the third is to say that under Section 172 of the Constitution, in the corrective principle, enrichment has been recognized as forming part of that rubric. So there's nothing strange in that regard. If one, however, had a case that was premised on unjust enrichment ranging beyond the fact that one had paid an unlawful tax under protest, in such a case, it might be appropriate to say, well, I've got a review and I also have an action, and bring the action. But there's nothing that procedurally and or jurisprudentially requires that, except in circumstances where it wouldn't flow as it does in this case automatically from what one says. And then there's nothing, the thing in this case is that there's absolutely nothing in the answering papers before the court ar quo to suggest that there's anything wrong with it. And again, in argument, it was conceded that if the regulations fall to be set aside, then the repayment relief flows as a matter of course.
Now, if an order is made for that repayment, are there other payments that the applicants would have made to the state for the right to operate a casino that they had? I'm asking this question in the context that maybe usually, maybe all the time, I'm not sure, when the state grants you a license to do business, there is something that the state gets from you, some payment other than the normal taxes, you know.
Yes.
Get some payment, so you pay for the right that you have been given. You know, maybe annually you pay some charges, some fees. Would there be something that can be seen in that context that the applicants have been paying over the years? Or is the position that if these levies are repaid to the applicants, will the position be that for the relevant period, the applicants were enjoying the right that has been given to them by the state without paying anything for that right other than normal taxes?
Yeah, Chief Justice, two things in that regard. I believe that there are also license fees independent of the levies, but that can be verified. But when it comes to these levies, it's only, and this is critical, it's only the difference between the increased levies and the levies in terms of the regulations as they stood before the increase that are at issue. So what was paid under protest was the full amount. What's being reclaimed in the repayment relief is simply the difference. Okay. And if the order is granted as we seek it, then henceforth yes, it is confirmed that there are independent license fees that are being paid. Then henceforth, one would continue paying levies, and those levies would be paid in terms of the undisturbed regulations before the amendment, until such time as the provincial legislature does what Section 228 of the Constitution and the Process Act require it to do. So there's no situation that people continue without paying levies. And those levies were rates. They're progressive and they're percentages. So in other words, this is why I said earlier, this argument about inflation is a very strange one, because if costs go up and revenue tends to go up, then 10% of more is 10% of more. So if there's nothing wrong with that level, then that will continue to apply.
Okay, no, thank you, Mr. Snickers. I don't see any further indications. Justice Rogers, yes.
Yes, I just wanted to go back to the delay question, and I don't invite you to give any evidence from the bar, but one perhaps obvious question which might arise factually in regard to delay is, when did these applicants become licensees of casinos? The argument assumes that they were the licensees in 2002, but I don't think that appears from the papers, does it?
I can answer Justice Rogers in two ways. The question is a pertinent one, because the assumption is certainly not necessarily borne out on fact, which does complicate it considerably. So that from a corporate reality point of view, simply to say, well, these casinos were around all the time is not correct. There's nothing about that, as far as I know, in the papers to assist in that regard. But what I can say is that it is a pertinent objection to the delay point, because one doesn't know what the facts are in that regard.
The other thing I'd like to raise, and it arises from something the CJ has just canvassed with you. When a state, an organ of state, we haven't been told about the processes by which the present applicants obtained their casino licenses, but I'm not sure it's altogether unusual when the state is inviting people to put forward proposals in order to get a valuable license, that the state can expect to receive money in return for that privilege. And part of the money part of assessing who gets the license may be affected by what they are prepared to offer. I'm thinking of mineral resources, fisheries. One might say, for example, in regard to gambling, that it is notionally an activity which the state itself could conduct profitably by state-owned casinos. And if it is going to allow private enterprise to do so, it may expect to receive money for that. Now, if for them, assuming in the present case, the right to or the request for proposals, I think, or request for applications is how these gaming licenses are initiated, included the opportunity of putting forward a payment proposal. Say, we'll pay you 2 million rand a year. That presumably wouldn't be a tax. It would simply be the public authority being remunerated in a competitive process for allowing people to undertake a regulated activity. You can tell me in a moment whether you would accept that that wouldn't be a tax. But mightn't these gaming levies simply be an alternative way in which the state is remunerated for allowing people to undertake a highly profitable activity which might otherwise have been undertaken by the state itself?
If I may answer that first by saying that there's a distinction between those situations where there's a bespoke activity and there's a charge, or there's a bespoke activity, it is a regulated activity, and there is a charge attached to its regulation and to the activity, and that charge goes undeniably towards, or at least predominantly towards, defraying the cost of that regulation. Then on those cases that were considered in Shuttleworth and the comparative cases and cases like EPOL and Maysboard and so on, one would accept that that would then not be a tax. If in the example, specific example given, there was a proposal on, well, what can you offer to the board for the board's purposes, for the board itself to use for its regulatory purpose in regulating gambling in the industry, there would be an argument that that kind of payment would be more along the Maysboard and EPOL kind of payment than a tax. If, however, it becomes simply imposing a special income tax on a particular activity in a region, on anybody who's involved in that activity for the benefit of the province as a whole, then that is exactly what Section 228 says ought to be done by the legislature. And so if that were a case of saying, can you put forward proposals for what would go into the central governance fund for general use for the province to better the lives of the province, then it would be a strange situation, but one would be making proposals for taxes. And I'm not quite sure how that sort of process would pan out.
Yes, when one thinks, for example, of one of the AXA cases, which was selling or inviting tenders or proposals to operate concessions for motor vehicle car hire spots at an airport. That the bid might go subject to preferential procurement considerations to the person who offers the most. I suppose the levies in this case can't really be put in that category because it's a standard levy. Whoever is the licensee pays it. It's not an amount bid by a licensee for a concession.
Yeah. And the big thing is there's no earmarking. There's no earmarking at all. This goes straight into the pot. And the board gets from the central provincial government gets grants, and there's just no relationship whatsoever between those grants and these levies.
Well, I'm not sure that earmarking would necessarily be essential in the examples I put, where a concession is effectively being sold to the highest bidder. The money might very well go to a province or national government's general purposes.
But what one would have there is you might say that on the question of where the money goes and what it's being used for, you're on one side of the line, but then you're in the Shuttleworth link between the close link between the behavior that's being regulated itself, the activity, and the money that's being paid, because that's also the distinction in Shuttleworth. You're regulating conduct. You are saying everybody who exports capital pays 10% on that capital. It's linked to that which you're trying to regulate. It goes up and down with that which you're trying to influence the behavior of. Very different from saying, give me 10% of your turnover.
Thank you.
Okay, thank you. I don't see any other indication from colleagues.
Chief Justice, if I may.
Yes, please go ahead.
Mr. Snickers, I would like to raise two aspects with you. The first relates to a response that you gave to a question that was put to you by Justice Collopin, and you've made the submission that Section 87 of the Gambling Act is unconstitutional in that it leaves the imposition of a tax or a levy to someone other than the legislature, namely the MEC. But is that the correct conclusion if one has regard to the provisions of the Act itself? It seems to me primarily to be a question of interpretation. And if you have a look at Section 87(1) of the Act in paragraph A, which you've quoted in paragraph 16 of your heads of argument, it determines that a holder of a license shall be liable to pay a gaming levy which shall be calculated on such basis and at such rate as may be prescribed. So that portion of the section imposes the levy. The prescribed portion, if one reads the section as a whole, then arises from subsection 3, which then leaves it to the MEC to make regulations. One doesn't know why the legislature chose to do it in that way, but that's what it's done. To prescribe the matters in respect of which gambling levies and fees shall be payable and the tariffs relating thereto. It doesn't authorize the MEC to impose a levy. That's done in terms of Section 87(1). What it does, it simply leaves it to the MEC to determine the activity in respect of which a levy is to be paid and the tariff relating thereto. So the amendment that has been made, does it not simply amount to an increase in the tariff and identifying the activity in respect of that which that increase would apply? If one has regard to the regulations, it identifies table games, gaming machines, and card games. Those are the activities. So it doesn't authorize, on my reading, the MEC to impose a levy or a tax. That is done in 87 by the legislature.
Justice van Zyl, the answer to that is that there is nothing more of substance in the levying of a tax than determining what it is for and how much it is. And that is what 87(1) and 87(3) undeniably give to someone other than the legislature and give to the MEC. So if it were to be read, for example, in the following way, to say there shall be a levy payable, and even if it's accepted that that's a tax, and such levy shall be as prescribed in regulation in relation to such activities and the tariff that should be applied, that is delegating that taxing power to whoever is the party that decides how much and for what. The mere fact that because one could take that further, and one could say that the taxing power which is imposed on the legislature implies there will be a tax. So you would don't even need the legislature to say people are going to be liable for tax. The real question is who levies that tax, and in these provisions, it's not the legislature doing so, and that's the problem. It is. I need to stress, however, that if the court were to find that the empowering provisions don't themselves necessarily impose the power to tax on the MEC, but the regulations make it clear that that's what they are doing, then the regulations are set aside on Shuttleworth and the empowering provisions need not be.
Yes, thank you. I understand that part of it. The second aspect that I want to raise with you is your reliance on a concession that was made in the High Court, and it's an aspect that you rely upon quite heavily with regard to the review part of your argument. The correctness of that concession, do we have to have regard to the material that was before the High Court and the basis on which that concession was made? Do you agree that that can only be arise from the material that was before the High Court? So one will have to look at the record and see what was before the court at the time when the concession was made. Now, if that is so, I see you nodding your head. If that is so, if I can interrogate then the correctness of that concession, if I can refer you to volume 1, page 13, that is the founding affidavit of the applicants in the matter before the High Court, where this issue is raised as a third point, and it's under the contention that the applicants contend that the decision to promulgate the impugned regulation are unlawful and reviewable on the following grounds. Third ground is simply that neither the Minister of Finance nor the Northwest Gambling Board concurred with the impugned regulation. That is then followed in the affidavit itself. Further on in the affidavit, page 55 of the same record, paragraphs 116, and further under a heading dealing with a concurrence, whether or not there was concurrence with the impugned regulation. And the allegation is made in 118. And I read, there's no indication either in the amendment or elsewhere that either the board or the finance MEC concurred with the impugned regulation. Now, that seems to me, unless you can direct me to anything else, seems to be the only basis upon which that aspect of the regulation has been attacked. Now, the fact that there's nothing in the amendment itself to indicate that there was concurrence, that in itself doesn't mean there wasn't concurrence. So this allegation doesn't really have a factual foundation to it. And then if one then goes to the answering affidavit, those allegations are dealt with in volume 7 at page, I see there's a numbered page at the top. It looks like 584, paragraph 12.4. And then what it effectively amounts to is that it is a denial by the first respondent to the fourth respondent of that allegation. So it's a simple denial. The question must be asked in view of the absence of a factual foundation for the allegation in the beginning, whether or not anything more was required other than a simple denial. Now, from your argument, I then gather that you rely on two aspects, and the one is, in this regard, the one is a letter that was written by the head of department to the head of department of the, written by the head of department of Treasury to the head of department of the Department of Economic Development and Environment. And it seems to me that that is what the letter which is being relied upon. But can you look at that letter in isolation? Because it was preceded by a letter which you find on page, in volume 8, on page 808. That is a letter from the MEC to his colleague in Treasury, and where he advises him, he sets out in quite detail that he intends to amend the tariffs, and he says why he's doing so. And he says, then in conclusion, MEC, my office seeks your indulgence in terms of the Treasury regulations as amended to approve the proposed gambling tariff structure. It's then responded to by the head of department, but there's nothing in that letter on page 812 of the same volume that indicates that it is the head of the department that is concurring. It seems to me that he is simply writing on behalf of his head, which is the MEC. So as a factual, as a fact, can one come to the conclusion from those two letters alone that it was the head of department that was concurring and not the MEC? The other document that you relied upon in your argument in this regard is the affidavit deposed to by the MEC for finance, and you'll find that in volume 7 on page 606 and further. It's a short affidavit where he then refers to, if I'm correct, yeah, I think that's the letter, but he refers to the Public Finance Management Act and the delegation of powers to the head of the department. And you seem to rely on that letter as an indication that it was the head of the department that made that concurred in the decision of the MEC, namely the first respondent. But if you read the affidavit as a whole, in paragraph 1.9, he says, I confirm that I have by virtue of the power so delegated, and this is the affidavit of the head of department, authorized the head, sorry, it is by the MEC, authorized the head of Department of Economic Development, Environment, Conservation and Tourism to depose and attest to the founding affidavit. So it seems to me that it relates to the authority to depose to the affidavit as opposed to the concurring in the decision to increase the tariffs. I may be wrong. If you can just indicate to me on the papers, where do I find the relevant portions that you rely upon on the factual correctness of the concession that was made?
Thank you, Justice Ansel. First, yes, it is correct with great respect that the concession itself ought not to be decisive. In other words, if it were clear from the papers that the concession is wrong, then it ought not to be decisive. It is clear from the papers, however, that the concession is correct. The first answer is that the founding papers were supplemented by the supplementary founding affidavit in the review under the Rule 53 process. And that is at page 415, paragraph 59 to 64. We're now having been, so one raises the point in the founding affidavit to say there's no indication that this power had been, this concurring had happened. And then one gets the record, and then on the basis of the record, one indicates that this concurring didn't happen, and it's the HOD that did it and not the Treasury MEC. And the other points that we made that I didn't refer to in argument, I don't want to detract from answering the question, but those are in our heads, paragraphs 97 to 103, that make it clear the other problems with the purported approval. But that point is therefore squarely raised in detail in the founding papers before the answer comes. The important point, and it's a point that I made in passing in the opening, the important point is that the case for the MEC on the papers, if one forgets the concession completely, is not read the letter and the letter communicates a concurring decision by the Treasury MEC. That's not the case. The case is, on the contrary, the head of department made this decision and was properly delegated to do so. That reference is in the answering affidavit, our quo, at paragraph 12.3.13, page 501. If I could just read that. That was, I also referred to that up front. The fact that Kunene was, this is the head of department, as is evident from Annexure ID1 to his confirmatory attached here too as Annexure LT2, duly authorized to, in terms of the powers delegated to him by the second respondent, concur on behalf of the second respondent to the amendment of the sub-regulation 1 of Regulation 73 of the Northwest Gambling Regulations. So the case from the MEC is not the opportunistic one, which is to say, well, if you read the letter, it may have been a communication by an agent of that which the Treasury MEC had decided, and there was a concurrence. That's not the case. The case is Kunene, the HOD, did the concurrence, and why was he able to do so? Because he had the delegation. It's then when one goes to that delegation that is relied on, and one finds that on page 528 to 9 on volume 7. That's where one sees that delegation has nothing to do with the concurring powers under section 87.3 of the Northwest Gambling Act, but that's the PFMA accounting officer powers. And then there's the additional point that there is, in any event, you cannot delegate that 87.3 power. That's not a PFMA type power that can be delegated. So it is correct that the original letter, call it the request for concurrence, comes from the MEC Economic Development, i.e. the one who makes the amendments, and is sent to the Treasury MEC and seeks approval. And one can quibble, and we've quibbled in our heads about the kind of approval that's sought and what's really sought and so on. But that's correct. But the purported approval then comes from the HOD, and the case is not. That is the approval from the MEC. The case is that is the approval from a duly delegated official. Here's the delegation. One looks at the delegation, it's the wrong delegation, and it's not something that can be delegated. So I don't know if that answered all the questions that were put.
Yes, thank you.
Sorry, Chief Justice, may I just go back to something that has occurred to me?
Yes.
Mr. Snickers, I was just looking for the manner in which the respondents answered paragraphs 59 to 64 of your supplementary founding affidavit, which is where you elaborate on the absence of the Treasury MEC's concurrence with reference to the Rule 53 record you had received. And I noticed from the answering affidavit, unless I missed it, but I've only noticed it now, that the respondents do not traverse the supplementary founding affidavit at all. In fact, in paragraph 3 of the founding affidavit, where the deponent says what he has read, he doesn't say that he's read the supplementary founding affidavit. Have I missed something?
I don't think, Justice Rogers, that you've missed something. I think that is correct. But the point is, however,
perhaps the Respondents' Council can correct me if I've mistaken, but I've just noticed that now because I was aware that you had amplified on this point in the supplementary founding affidavit, which is why I was keen to see what had been said about it in answer, and it isn't dealt with.
That is with respect correct, but the point is that when they do deal with the delegation point, because it was raised in the founding affidavit, or at least with the concurrence point in their answering affidavit. Yes, I in fact, my learner junior, I'm just doing three things at once, I apologize. My learner junior points out that in our reply, paragraph 8 of the reply, which is at volume 610 of the record, we point out that the answering affidavit does not respond to the applicant supplementary founding affidavit at all. But if I can then just make that point, that in the answering affidavit that does respond to the concurrence point, that's where they tie their colors to the mast, and I've given the reference in page 501 where they say, but what's the problem? It was done by the HOD who was properly delegated. Here's the delegation.
Thank you.
Thank you very much. I think we are now ready to move to the Respondents' Council. Thank you very much, Mr. Snickers. I now give Ms. Moncho Moloisane, Counsel for the Respondents, the opportunity to address us. You have 30 minutes to do that without us interrupting you. Obviously, you can finish earlier than that. If you finish earlier or you will take less than that, you can tell us. But your 30 minutes starts now. Ms. Moncho Moloisane, are you there? Can you hear me? Mr. Naidu, has she been disconnected? Do you know what's happening? She's not responding.
Chief Justice, advocate is present in the meeting.
Oh. Can you hear me, Ms. Moncho Moloisane? Are you muted? I see your junior counsel is there. I can see her, but I can't see you, and you are not responding. Ms. Bokaba, are you able to tell us anything, or are you able to take over? She can't hear me either.
Chief Justice, if I may.
Yes. Justice Theron?
I do, yes, I believe that counsel is using the junior counsel's laptop. Even though we see the lead counsel on the screen, I don't think that admission when we admitted her into worked, and then she entered on her junior counsel's laptop.
Oh, but then now, why is she not responding?
She seems to have become frozen now, Chief Justice.
Yeah. Mr. Naidu, do you think we should take a 5 minutes adjournment, or is it something that's beyond your control? It's on her side.
Chief Justice, I think that would be a good idea. It's not something I can sort out here, but I will definitely try and assist as much as I can.
Counsel has returned, Chief Justice.
Oh, okay.
You are muted, counsel.
Ms. Moncho Moloisane, can you hear me now?
She's still muted, it seems.
Unmute yourself, please.
Can you hear me, Chief Justice?
Well, I can hear somebody now. Is that Ms. Moncho Moloisane?
That's correct. My laptop had problems. I'm using my junior's laptop. As
Okay,
just
you can.
correctly said.
Okay, but you are able to hear me now.
Very well. I have connected. I hear you well.
Okay, all right. If showing us your face as you address us is not going to create technological problems, we end up losing you. That would be good to see you as you address us. But if it's going to cause problems, if we can hear you, that would be fine.
Justice,
yes.
if I may interrupt before, please can we ask counsel to disconnect from the other connection, please? From the laptop that's not working. Can you leave the meeting on that laptop, please?
Thank you, Justice Theron.
Thank you, Chief Justice.
Is that done, Ms. Moncho-Moloisane? I think we must take a 5 minutes adjournment and let Ms. Moncho-Moloisane sort out her problem so that when we come back we can start. Let's take a 5 minutes adjournment. We adjourn.
Court will adjourn until 12:30.
I think it is time now. Ms. Monjo Moloisane, can you hear me? Oh. Ms. Monjo Moloisane, can you hear me?
Thank you, Chief Justice. I can hear you now.
Okay, all right.
The issue of connectivity.
Okay, all right. You have 30 minutes to address us without interruption, and your 30 minutes starts now.
CJ, I'm sorry. I don't know
Yes.
if Justice Potterell is still with us.
That's fine. She will be connected, hopefully. But if it takes too long, we'll see. The idea is that even if one of us gets disconnected, we won't stop the hearing on the basis that it won't take too long before they are reconnected, and there will always be a transcript to look at what they may have missed. But obviously, if it takes too long, the disconnection, we might have to interrupt. Okay, Ms. Monjo Moloisane, your 30 minutes then starts now.
Thank you, Chief Justice. Chief Justice and other justices, I mean, we are here dealing with the confirmation application, which is based on the judgment of the court accord. But now, in our heads, we have dealt with the judgment as it is, that there is no way where the court accord focused on the various provisions, and there is nowhere in the judgment where the various provisions have been analyzed to say why these provisions should be declared unconstitutional. Actually, in the judgment itself, we see that where the judge attempted to deal with the issue is contained in 3 paragraphs. Paragraph 14, 15, and 16 of or actually up to 17, 14 to 17, where the court accord held that Advocate Judicial wisely considered on behalf of the 4th respondent that the delegation of authority was not in line with the principles as set out in the Constitutional Court. And the result of a lack of delegation of authorities that the application has to be successful. Having said that, she continued to say, having found that the delegation was not valid, I need not consider any of the issues raised by the parties. Now, our submission, Chief Justice, is that the judgment as it is does not analyze these impugned provisions, that is Section 84, 1, Section 87, 1 to 3 and 3. That being the case, the conclusion that the court accord came to in giving the order from paragraph 18 seems to be not grounded at all. There are no provisions, there is nothing except that the court accord only analyzed the various decisions of this court, and there is nowhere where she indicated on what basis could she say Section 84(1) is unconstitutional. On what basis could she say Section 87(3) is unconstitutional? On that basis, Chief Justice, we submit that the judge did not apply the principles to the fact, the principles that she highlighted from the various judgments to the facts of the matter. And hence we submit that there was no rationale for her to have arrived at the conclusion that at the conclusion set out in paragraphs 18.1 to 18.6 of the judgment. And we further submit that, as my learned friend correctly considered, in the judgment, she, that is the court, based this decision on paragraph 16. What she says at paragraph 16, where she states, having considered the merits in the application, the court is satisfied that the proper case has been made out for the relief sought in terms of the notice of motion. As to on what basis this was done, there is still a lacuna. And then that incorrect, we submit that reliance on the concession made was improper and not justified. And hence we refer to this court to the decision of Matatiele, of Kruger, and of Tenje, where this court held that a court is not bound by a legal concession. It has to consider the concession to be wrong in law. If that concession was wrong in law, the court should not even have dealt with it, or if the court was dwelling on that in order to justify the order granted, then the court should have clearly stated that in the judgment. We say in this regard, the court failed. Perhaps I need to refer to this court to the cases that we quoted in our heads of argument. We have quoted Matatiele, Kruger, and the Tenje, and we say in Matatiele, the court expressly held that accepting an incorrect concession on a point of law would lead to intolerable situation where courts would be bound by a mistake of law on the part of a litigant. We submit that the reliance on the concession that the MEC's regulation and making power are uncontrolled is without any merit. And we again referred this court to at paragraph 36 of our heads, the case of municipal employees, where the court had to address a similarly worded regulation, such as regulation 73.1, that is a regulation making power. The Honorable Justice Mtamtla said that the power given to the MEC under Section 4 is indeed very wide. But then she says, wide though this power may be, this does not mean it is without limit. And perhaps I need to just quote what this court stated through Justice Mtlang. The only source of such power for the regulator would be the catch-all power to make regulations, providing for all matters which the regulator considers necessary or expedient for the purposes of the case. This power, however, does not extend to a purpose not sanctioned by the original legislation. And compulsory membership of one of the KwaZulu-Natal funds, making membership of one of the KwaZulu-Natal funds compulsory would be ultra vires those laws and hence in conflict with the constitutional principle of legality. And then at paragraph 37 of our heads went on to deal with the case of Minister of Finance and Afro-Business, the so-called Afro-Business judgment, where I quote, the ultra vires doctrine, which is a subset of the principle of legality, is central to the determination of the lawfulness of the exercise of public power. and it demands of every exercise of public power a consistent compliance with the bounds set for the exercise of that power as provided for by the applicable law and constitution. And the exercise of such power must therefore happen within the bounds set by the legal framework. Now, what is the legal framework in this case? Starting with the powers vested on the MEC to amend Regulation 73(1). The starting point, Chief Justice and Justices, is Regulation 73, Section 87(1). It's clear and unequivocal. And you should, or perhaps I can just read it to say only subsection A. A holder of a license shall be liable to, at such intervals as may be prescribed, pay a gaming levy, which shall be calculated on such basis and at such rate as may be prescribed, and be payable in the manner and before the date as prescribed. Chief Justice and other justices, we submit that these provisions, this 87(1)(a), should be read together with 87(3), where it says the responsible member may, with the concurrence of the MEC responsible for finance, by notice in the Provincial Gazette, make regulations prescribing the matters in respect of which gambling levies and fees shall be payable and the tariffs relating thereto. Now, there is no reference to the word tax in any of these provisions. I mean, Section 87, and the same with Section 84. We do not find any reference to the word tax. That being the case, we submit that the MEC acted intra vires in that she was not dealing with the imposition of tax or taxes, but was merely exercising the power vested on her. And a lot has come out as to whether the HOD, the concurrence that was made, the concurrence that was relied on, that the HOD for Treasury wrote or communicated with the ministry, with the HOD for Economic Development. We submit that that was proper, as it was done within the powers that have been delegated to them. But such powers have been expressly delegated by the Public Finance Management Act. We are dealing with issues of finances. And I reiterate, there is no reference to any to taxes in this case. So at paragraph 43 of our heads, we have referred to the case of Omar, of Momoniat, and of Afrobusiness, all of which come from this court, where the court held that the statutory language imbuing the executive with powers that are necessary or expedient were considered to denote that the functionary so empowered had the amplest possible discretion. But within that provision, we find that regulatory means the powers are curtailed. Contrary to what my learned friend submitted, these powers are clearly curtailed from the wording of these sections. And these provisions cannot be read in isolation, justices. They have to be read together in order to grab or to understand the actual intention of the legislature when promulgating these provisions. In this instance, we submit that the MEC did not at all act ultra vires, and this we deal with under subparagraph E. And from paragraph 32 of our heads. We submit that the act we're relying on is to amend Regulation 73, which was done in 2020, January 2020, was done in accordance with the empowering legislation and cannot be faulted. So we further refer to the case of paragraph 36 of our head. And which I have just quoted, and 37, the case of agribusiness, which we have also dealt with. And the case of Omar that we dealt with at paragraph 43 of the heads. CJ and justices, we should be mindful of the fact we submit that since this regulation, that is Regulation 73.1, has consistently been applied since 2002, after the promulgation of this, when the regulations came into operation. And it is only the amendment thereto, which came into operation in January 2020, which is being attacked. Then, on this basis, we submit that the MEC's powers, as appears from these statutes, are controlled, and the submission that the MEC's powers are uncontrolled is without any merit. And hence, we noted that the two HODs communicated regarding before the amendment could be effected. I mean, Section 87.1 requires consultation with the board. This, from the papers, from the record, we know happened. And Section 84.1I requires the regulation to be prescribed that is necessary or expedient and to achieve the purpose and objects of the Act. We saw this happening, and Section 84H requires the amounts or the levies required to be prescribed. And that's where the case of agribusiness comes in. So we submit that properly construed, the impugned provisions are limited and controlled, and hence they should, the finding that they are unconstitutional cannot stand. What should and we have dealt with the issue of the ultra vires, and I have referred you as well to this issue of the criticism of the judgment, where the judge failed to clearly deal with the judge failed to analyze the provisions and to state to what extent can these provisions be impugned. We say in the judgment itself, it is what the judge has stated is clear and straightforward. She did not consider those provisions at all. And in the circumstances, the only relief that can be granted in this respect is to in fact, the relief that is being sought cannot stand. At best, this court should refer this matter to the court quo for all these issues to be properly ventilated. To what extent the judge has to deal with how the constitutional attack on these provisions should stand. As of now, we do not have any reasons. There are no reasons at all. And in the order, we see that at paragraph 18.2, she says, the amendment is declared to be unconstitutional, invalid, and of no force and effect. This only pertains to the amendment of January 2020. The previous years, all these casino licensees were paying in accordance with what was required of them and the legislate, in terms of regulation 73.1. So we submit that this matter should be referred back to the court for the court to properly ventilate these issues. And then we submit that the powers vested on the MEC, as appears from the Gambling Act, Northwest Gambling Act, should remain unfettered, as the executive authority, that is the MEC for Economic Development, did what was expected of her in the circumstances. And in our heads, at paragraph 49 of our heads, we also deal with the exercise of establishing whether a power is conferred. So we refer to the case of Chisuse and others versus Director General, Department of Home Affairs, where it states judges must hesitate and in inverted commas, to substitute what they regard as reasonable, sensible, or businesslike for the words actually used. To do so in regard to a statute or statutory instrument is to cross the divide between an interpretation and legislating. And the court went on to say the purpose or contextual interpretation of legislation must remain faithful to the literal wording of the statute. And we say the Northwest Gambling Act expressly contemplates in subsections 84(1)(e) that the MEC may regulate any matter pertaining to gambling levies and fees. And we submit that the MEC enjoys the power to prescribe the levies and fees payable by licensed holders and casinos. He has in fact done so, as appears from regulation 73.1. Justices, regulation 73.1, for record purposes, it provides that the licensee shall pay a gaming levy in relation to each of its licensed casinos, depending on the licensee's gross gaming revenue. This is a way of regulating the industry and generating revenue for the province. And I have already indicated that it is not and cannot be a tax under any circumstances. And you say the power to increase the levies and fees payable by casinos falls within the powers conferred unto the MEC by the Northwest Gambling Act. And
you are left with 5 minutes of your 30 minutes.
Then I will assign my junior to deal with the issue of the referral. In conclusion, we say the provisions cannot be struck down. There is no rationale for saying so. May I give the platform to my junior advocate, Bukawa, to deal with the next issue, which is, yes.
As a
Let us do so.
Yes, as a conclusion, I think briefly on the points as delegated.
Hang on. There was some interference. I certainly could not hear you properly. Try again.
The conclusion, this is to justice and other justices. Might I be permitted to just address?
No. There is interference.
Chief Justice, I suspect that they have more than one device on.
Yeah, please have only one device on. Thank you, Justice Matlanga. No, you still have that. Please switch off other devices. Okay, try again. Otherwise, your leader must just continue and let us finish. We have lost quite some time.
Yes, Chief Justice. I think I'll be very brief on the 2 points that have been requested to address. The first one concerns the question of, which I think was raised by Justice Theron, on whether or not would this court be, or rather whether or not this court is, whether or not it would be desirable for this court to sit as a court, as a court of first and last instance in respect of some of the matters which the High Court failed to deal. And these matters, as Senior has indicated, is that from an assessment of the judgment, we know that the judge in the High Court only based her judgment based on the concession insofar as the delegation that question is concerned. However, nowhere in the judgment do we find a consideration, an analysis, and a determination of some of the issues raised in the Korakur, particularly concerning the questions of the declaration of constitutional invalidity of the impugned provisions of Section 84, 87.1, and 87.3. Secondly, the question of the review. Firstly, that again, the applicants in their heads of argument concede that point, that the judge in the Korakur failed to pronounce on the question of the review. And importantly, as also appeared in this court through the debates between the justices and our learned colleague for the applicants, important questions arose insofar as the question of the review. Particularly, firstly, starting with one of the points raised by the Chief Justice, insofar as the applicability of PAJA to the question of the review of regulations. That question, Justices, I would submit, remains unanswered, save for the answer that was given in the Mostert case in the Supreme Court of Appeal. But at this level of the court, that question has not yet been answered. Now, the High Court, again, did not consider that question, which would have given this court perhaps an opportunity if the High Court had dealt with that issue and given its reasons and its findings. Perhaps that question could have properly arisen in this court for the court to properly canvass and consider at that point. And then the same goes for the other issues, and also one of the questions raised by the Chief Justice in relation to the desirability of this court granting the repayment order. The challenges posed with that kind of with this court making that kind of an order, wherein there's no proper quantification of how much ought to be paid. We just know that the applicants seek an order that certain money is paid subsequent following the amendment of the regulation, assuming that the regulation is to be declared invalid. How much would have to be paid? That would submit that this court would not be properly seized with that kind of a question, given the complexities arising from the calculations, the payment, the question of whether or not is the question of levies only to be refunded, is the question of penalties, the question of interest. All of those questions arise, and this court, as indicated, or perhaps as when Justice Theron posed a question to another colleague about the undesirability of this court being called upon to pronounce on those issues that the High Court failed to pronounce. And perhaps if I may refer justices to two decisions of this court. One of them is MM versus MN, 2013 ZACC. It's the decision of this court, which we do not refer in our cases, together with the Flexitex case. It's also a decision of this court, where the court expressly expressed, or rather the court expressed its the undesirability of it being put in a position where it has to sit as a court of both first instance and last instance. And recently again in this court, in the matter of Afrotex projects versus CETA and others, it's a judgment of this year, this court, where the court was seized with a similar application where the court Akpo had failed to pronounce on most of the issues raised by the parties in the court Akpo. And this court, in that judgment, which was penned by Justice Kwalapen, said, perhaps if I may quote paragraph 28 of that judgment, said that a court must effectively dispose of the dispute that has come before it, and in doing so, it must, in accordance with its powers relative, or rather, it must act in accordance with its powers relative to the matter at hand, and then that this, after all, is what after all provides the certainty and finality that the party is seeking when they bring a dispute to a court. And then lastly on this judgment, like the following paragraph, the court then goes on to explain how the court's failure to pronounce on issues that are brought before it might compromise the questions of the right to access to parties. And perhaps lastly, Chief Justice, without me prolonging the 5 minutes that I've been afforded, on perhaps let me close on this point and then also address briefly the question of the cost. Is that
you have only half a minute left.
As a court, yeah. So, sorry, Justice. So, in these issues, our submission in this respect is that the court's failure to pronounce on these important questions, the questions of the declaration of constitutional invalidity of the impugned provisions, the failure of the court to pronounce on the question of the review, in particular, the question of whether or not this review was brought within the prescribed 180 days, the question of the delay which the justices raised with the learned colleague for applicants, those issues are not properly canvassed. And I would submit that an appropriate order would be a remittal of this matter back to the High Court for all of these issues to be properly considered, so that should any of the parties who are unsuccessful in that matter, then that party would then have a properly prepared judgment with proper reasons, and that party will then be placed in a position where they will be able to
your time is up.
Yes, thank you.
Thank you. Now, Ms. Monjo, you need to be available now because there will be questions for you. I hope that there are not going to be any further technical glitches. Colleagues, those who have questions for Ms. Monjo Moloisane. Ms. Monjo Moloisane, you accept that the delay point was not taken by the respondents in the answering affidavit?
We do accept that, Chief Justice.
Given that, do you not accept that it's not permissible for the respondents to argue that point?
Perhaps I need to refer this court, Chief Justice, to the judgment of Mostert, paragraph 36.
Yes.
Where I had it flagged, I can't find it. I'll quickly find it now.
Well, maybe give me an answer first before you tell me what you rely on. Is your answer yes or no? Is it permissible?
It is, Chief Justice, permissible based on the findings of the Supreme Court of Appeal. And I want to quote this.
Have you found it?
Yes.
What does it say?
Of Mostert. It says, this brings me, that is the Supreme Court of Appeal, not this court. This brings me to the question whether the court erred in allowing the minister to raise the point, that is the point of delay, when he had not done so in his papers. Where it appears from the applicant's papers that there had been a delay of more than 180 days, and there is no application for an extension of the period, a respondent is, in my view, entitled to raise the point in argument that the court has no power to hear the review. It's a point of law, and it goes on to say, this is not raising a defense. It is a submission that on the applicant's own papers, the court has no power to entertain the review. If the court is entitled to raise the point mero motu, then there can be no reason why the respondent should not be allowed to raise it. It was in any event dealt with by both parties in their heads of argument, and the appellant elected not to seek leave to file a further affidavit. This is the case of Moster, to which I referred you, justices to.
Now,
and it deals mainly with Paja.
Now, it may well be so, but that would, I guess, depend on the wording of the relevant statutory provision. For example, there are points that a court may take mero motu, even if none of the parties has raised. But there are points which a court may not raise mero motu if they have not been raised by the parties. And I believe an example of a point that a court may not raise mero motu would be prescription, if it has not been raised by the defendant or respondents. But if, for example, a statutory provision says something along the lines that the court may make a certain decision on a certain matter, provided an application is made within a certain time, that may suggest that the court only has power to make that decision if the application has been made within that time. And therefore the court may be not only entitled, but actually obliged to first check whether, before making this decision contemplated by the legislation, that condition of the application having been made within that time has been met. So that even if the point is not taken by any of the parties, the court would be entitled and actually obliged to say, well, before I exercise this power, there's a condition that must exist, and I want to know whether this application has been made within this time, because on the face of it, it does not appear that it has been made within that time. But there may be another formulation which, in regard to time, which really is such that if the other side has not taken it, the court should not take. So the question, I guess, would be whether a section 180 is phrased, I'm sorry, the paja is phrased, the wording is phrased in such a way that you can take it and without any problems. Part of my concern is simply that a delay may involve factual matters which the applicant might have to deal with if the point is raised. But of course, the other side of the coin is that there may be certain statutory provisions where it is the applicant who, whether the matter is opposed or not, must satisfy the court that he or she falls within the section that they are supposed to bring the application under, and doing so requires that they should, among other things, say this application has brought within this time that is prescribed, or if it is not brought within that time, they must indicate that it is brought outside of the time and then either ask for an extension or apply for condonation. So maybe it might depend on that.
Thank you, Chief Justice, but we refer this court to the case of Mostert, as it was the facts were nearly similar, and the challenge was, the application was brought in terms of Paja. And my learned colleague, Mr. Snakers, admitted that what happened in respect of that amendment to Section 73(1) is an administrative action. And he considered that it's subject to Paja. And hence we rely on this case, as the parties also were relying on Paja. And in this case, the 180-day period had already lapsed, long lapsed, but the SCA went on to afford them an opportunity to deal with the issues and to say, but whether or not this court, the SCA could or was justified in law to entertain any application that was brought in the court of quo in terms of Paja, where the period had lapsed.
Yes.
We find that this is still the correct judgment to be applied. This court is actually empowered to consider the issue of delay.
Thank you.
As a court pleases.
I don't see any indications from colleagues.
Yes, I wonder if I can just raise a general question with Ms. Monsha Molusani. When I read the respondents' written submissions, I almost got the impression that the authors of the respondents' submissions had not read the applicants' submissions. Were the applicants' arguments to the forefront of your mind when you drafted your submissions in this court? Sorry, I'm not hearing a response.
We did, as a legal team, consider those submissions.
Well, if one of the important things in this case is the interpretation of the concept of provincial legislation as it appears in Section 228 of the Constitution and as defined in the Provincial Process Act. Where do I find your submissions on that question? All I see in your submissions is on that question, which seems to me to be a very important one, is paragraph 88 of your submissions, which just repeats a conclusion about it refers to taxes imposed by national legislation. Where have you dealt with the applicants' submissions where they analyze the wording of Section 228 and the definition in the Provincial Process Act? Have you addressed it anywhere in your written submissions?
Justice, so I have to concede that we did not.
Where do I find in your written submissions an acknowledgement that the concession, which, as the judge understood it, that the judge had misunderstood the concession and that the concession didn't relate to the MEC's statutory power to make regulations, but to the question of the Treasury MEC's concurrence for purposes of the validity of the regulations? All I see on that question is paragraph 74 in your submissions, which adheres to a position that the concession which your predecessor made in the High Court was in fact the concession on which the judge relied. But now the applicant has said in its application in this court and has said in its written submissions very clearly that that was not in fact the submission, the concession made, and a transcript to corroborate that was attached. And yet, as far as I can see in paragraph 74, your submissions entirely ignore that and proceed on the basis that the concession which your predecessor made in the High Court was in fact the one which the judge said. Now, where do I find that question dealt with?
Thank you, Justice. We rely on the judgment itself. That is what the court call in the judgment. It's a paragraph.
No, I appreciate that that's the very point the applicants have made. They said that is what the judge said, but it isn't the concession which your predecessor made. And they attach a transcript to show us what the actual concession was. It was on a different point. So we are concerned with the actual concession made, not with the judge's mistake about it. Now, where do I find that you deal with the mistake and with the concession that your predecessor actually made? Do you deal with it anywhere?
We start at paragraph 72 to say, from the above quoted authorities, it is clear that our courts differentiate between concessions of law and of facts. But where we
that's a general proposition. That's a general approach to concessions, yes. But the actual concession made here, where do you deal with the actual concession that your predecessor made? Not the one that the High Court wrongly attributed to your predecessor, but the one actually made. Do we see that anywhere in your submissions?
In paragraph 74, we only refer to what is written.
And just one more example, but I think I could go through every point in this case and do the same exercise. You'll recall that in the affidavits and then in the submissions in this court, one of the grounds upon which the applicants rely for the review of the regulations if the statutory invalidity point fails is the irrational and unreasonable reliance which the respondents placed on inflation. And in paragraph 96 of your submissions, in a single paragraph, you simply parrot a point about that the MEC considered inflation. Do you anywhere address the applicant's submissions on the question of inflation? One of the points they made, which does seem to me to be fairly elementary, is that if you want to take into account that the economy is sluggish and therefore not to impose too much of a levy on the casino operators, you raise that doesn't justify a lower threshold, it justifies a higher threshold at which a levy becomes payable. Now, do you address that anywhere?
I think we addressed it at paragraph 94. I mean, under the heading, it starts at paragraph 93, under the heading, ground number 3, the rationality, reasonableness, and consideration of relevant provisions. That's 93.
Yes, well, I don't see that paragraph 94 addresses the applicant's arguments at all. And 96 simply says that the MEC took inflation into account. Now, we know that, but we don't know whether the way the MEC took it into account was remotely rational or reasonable. The applicants make submissions on that, and you make no submissions in response.
Thank you. But at paragraph 96, that's where we state that the last time, on the last occasion when the figures were increased, the amounts were increased or revised, was in 2009, and hence this 2020 amendment to Regulation 73(1).
I won't pursue it. It doesn't seem to me that that's responding to the applicant's arguments. I must just say that particularly in this court, it seems to me particularly unhelpful for a respondent to put in written submissions that don't actually address the applicant's arguments, because they don't assist the court in determining whether the applicant's arguments are sound or where they might be questionable. But I won't take it further.
Ms. Moncho, can I raise this question of the concurrence? Do you accept that Section 87(3) of the Northwest Gambling Act require of the MEC for Economic Affairs, the responsible MEC here for the Gambling Act to have the concurrence of the MEC for Finance, or the MEC for the Treasury, as it's also called in the papers, to pass these regulations instead of gambling levies? Do you accept that?
That I accept. It's clear and unambiguous.
Okay, now, can I take you to volume 6, please, of the papers? And I'm referring to page 406, that's the printed page. That is the first applicant supplementary affidavit. And at paragraph 37 of page 406, as I say, it's the boldly printed page number in volume 6. It deals with the letter to the Treasury HOD, from the Treasury HOD to the head of department, which acknowledged the amendment of the gambling levies and taxes. And this is the important part, and then grants approval for the implementation of the amended Northwest gambling levies and taxes from April 2020. I lay emphasis on the word implement. This doesn't deal with the concurrence to pass these levies regulations at all. Do you accept that? It's a question of implementation. It's an approval to implement, not an approval to make regulations.
Indeed.
Quite apart from the fact of the delegation, which is another matter. Do you accept that?
I do accept, Justice Majid.
Yes, but now is that not fatal? I mean, that's not a concurrence to making regulations, regardless of the functionary has the power in law, which is the question of delegation. Is that not fatal?
Well, I submit that if there hadn't been any delegated authority, then that would be fatal. But it appears from that letter that the HOD was authorized by the MEC. The only question that arises is whether this particular legislation, the Northwest Gambling Act, does confer such or does empower the MEC to delegate the powers that are vested upon him or her by legislation.
That question has been dealt with thoroughly. I'm not going to go there again, but please go to page 458, same volume 458. Again, it's the boldly printed page numbers. This is a letter written by the head of department of the Provincial Treasury, Mr. Kunene. And he writes to the head of department of the economic development, the department responsible for gambling. This is a letter, firstly, then between two HODs, not between two MECs, which seems to undermine section 87(3) on the face of it. But let's have a look at it. And I'm referring you to paragraph 2. Approval is granted for the implementation, there it is again, of the amended gambling levies and taxes. And it says Provincial Treasury hereby approves the tariff increases, that's paragraph 3, for gambling levies and taxes for the financial year 2020-21 as required in accordance with PFMA and Treasury regulations. Where do you see a mention of section 87(3) there, Ms. Moncho Molasane?
I must admit it does not appear.
So it seems to me in sum, and I must tell you that on the face of it, I'm open to persuasion. Otherwise, the maxim delegatus delegare non potest applies here, and the Treasury MEC could not delegate this power. It seems to me on the face of it, if that is so, that there are three problems with this with this letter. First, that the HOD didn't have the power, the delegated authority. Second, that power is not to concur in the making of the regulations, but to implement them. And third and last is that it was done in terms of the PFMA, which is the Public Finance Management Act, a national act, and not in terms of Section 87.3 of the Northwest Gambling Act, which is at issue here. Three problems. Are they not all insurmountable in this case?
I must admit that they are insurmountable, Justice Majid.
Well, I want you to think carefully, because we are debating concessions here, and you must think carefully, because that is a legal concession as far as I can see, but also a factual concession, because you've just conceded on the facts of the letter and of what's contained in the affidavits that that this is what is occurred. So are you satisfied to make that concession? Because I want to suggest to you it's a fatal concession in this court, in these proceedings.
Thank you, Justice Majid. I'm not in a position to make that concession. Safe to state that, as Justice Majid, you indicated, you could not find anywhere where it was stated that way.
Yes, I'll leave it there. Thanks.
Thank you.
With the Monshamulasani, do you still persist, or does the respondent still persist with the argument on delay? Now, let's move away from whether this point was raised in the papers and whether the point is properly before us. Let's proceed on the assumption that the point may be properly before us. Do you persist in the argument that you've presented in the written submissions?
Justice Tron, we persist with that argument as, based on the authority in the, that we refer to, that is the most case.
So this also takes me to the point that Justice Rogers made. The argument that's been put up doesn't seem to apply in this case, because the written submissions addresses the 180-day limit in Paja. This leaves the confirmation application and the legality review open. It doesn't address that. The submissions that have been made do not appreciate that the promulgation of the amendment to the regulations is under review, not the promulgation of the regulations themselves. What do you say about that?
Thank you, Justice Tron. Firstly, it is so that the amendment was effected in January 2020. And by the time this application was lodged in the High Court, Northwest High Court, more than 180 days had lapsed since the amendment. But that is as far as Regulation 73, Sub-Regulation 1 is concerned. The applicants are attacking the constitutional validity of the provisions, Section 84, 1, 87, 3, 87, those provisions. Those provisions have always been there since 2002. And hence we submitted that they had ample time to challenge the constitutionality of the provisions. I'm not dealing with the regulation now. With Regulation 73, 1, of course, by the time they lost the application, the prescribed time limit had already passed. But it also serious with the provisions and the statutory provisions under attack.
In your heads of argument, you cite this court's judgment in Duplessis versus de Klerk. And you go on to make the submission that this court should treat the minister's regulation-making powers with, and I quote, appropriate judicial deference. That phrase does not appear in the judgment. That case concerned the application of the Bill of Rights to private parties in a defamation action. So I'm very confused as to the basis of that submission in your written submissions. So this is my question. On what basis do you make the submission that judicial reference should be exercised in this case, where provincial legislation gives the MSC the power to impose levies by way of regulation? And why does your heads of argument, your submissions refer to Duplessis versus de Klerk, which appear to me to be not relevant to this matter?
I'm quickly paging through that relevant case.
Well, Ms. Moncho-Molosane, I take it that you would know if you got that phrase from that particular case or not.
Yes, it came. I'm just trying to find this case now.
Is that with a view to checking whether that phrase is to be found in that judgment?
Chief Justice, at the time when we were preparing this, we were doing that under extreme pressure, as by now all the justices are aware that we are a completely new team, and hence those applications for condonation, the Rule 32 applications that we brought for the late filing of the answering affidavit, as well as the late filing of our head of argument. So although it is not good enough for counsel to rely on the fact that there was pressure, but unfortunately, this is a reality, and we are not relying on that now.
So is your answer to Justice Theron's question, therefore, that as you sit there now, you are not in a position to assure her that you got that phrase from that case?
In order to save time, I was just going through this, through our head to find where, the relevant quotation, but in order not to waste this honorable court's time, I abandoned that, Chief Justice.
Justice Theron?
Thank you, Chief Justice. I can only reiterate the concern that Justice Rogers expressed, Advocate Moncho-Molosane, that the heads of argument of the respondent do not appear to be directed at the case made out by the applicants. And it's not helpful to this court when we presented with heads of argument like that. But I'll move to my last question. The applicants are asking this court for what they call repayment relief. What are your submissions on the repayment relief? Would repayment relief, firstly, be justified in this matter? Does it flow, the relief that the applicants are asking, does it flow, if the court is with them, on the question of unconstitutionality? And if this court confirms the order of invalidity, does the relief flow from that order? Is that relief ancillary? Is that relief related to this court's power to grant just and equitable relief? And would it be just, or would it be equitable to place that burden on the provincial government?
Thank you, Justice Tron. With my submission is that this must be referred to the provincial government and should not be placed on this court.
Are you able to answer my question, please, Advocate Manjumulisani?
Justice Tron, you are asking if this court should rather leave the issue of repayment, unless I misunderstood you, Justice.
Okay, let me try rephrase my question. I know I put a few questions all together. Does the repayment relief, let me start. If this court was with the applicants and was inclined to confirm the order of constitutional invalidity, does the repayment relief that the applicants are seeking, does it flow consequentially from that order? Or does the relief that they are seeking flow from this court's power to grant just and equitable relief? And if it does, would it be fair to the provincial government? Would it be just to the provincial government that they must be reordered to pay that money, repay that money that they've collected?
Thank you, Justice Tron. I think this court is empowered in terms of Section 172 of the Constitution to grant the relief that will be just and equitable in the circumstances.
Thank you, Advocate Manjumulisani. Thank you, Chief Justice.
Thank you. I don't see any further indications from colleagues. Thank you. I'm now going to ask Mr. Snickers to present his reply. Thank you, Ms. Moncho Moleisane. I'm going to ask Mr. Snickers to address us in reply, and he has 10 minutes, which starts now.
Thank you, Chief Justice. A few points. The first is that a big part of our learned friend's argument revolved around an ultra vires point and on seeking to persuade the court that the powers that were exercised, in other words, the levying powers, were in fact powers that were conferred by the Act, and that these powers being conferred by the Act were very, very wide, and they included this power, and that is not has never been our complaint. Our complaint is not that the MEC acted beyond the power conferred on her, but the complaint in the plenary powers point and upheld by the court or quo is that it's those powers that are too wide. The powers in the Act are uniquely wide, in the words of the respondent. So it's not an ultra vires point, and all the law about ultra vires in that regard, and the fact that the Act does provide for it is not with respect helpful. On the issue of the delegation and the concession made, I believe it's not necessary to take it any further, save to point out that it's an argument that's made in our heads as well. Our learned friend said that because this had something to do with finance, that's why it would fall under the PFMA powers. But those Treasury regulations, as we point out in our heads, 3.1, 7.3, sorry, the Treasury regulations at issue, those deal with rates and fees in relation to matters that are not fixed by law and can't be fixed by law. So they do not relate in any way to powers such as under 87.3. For the remittal issue, I can only ask rhetorically, given what happened in relation to the concession and the merits of the concession, not just the concession itself, how on earth is that going to get better if that gets remitted to the High Court again on the papers? How is that ever going to get better? What purpose could there possibly be served on remitting that to the High Court and to have the concession made in the High Court be forced to be made again as it was made here in this court again, on the basis that it was a correct concession. In the our learned friend who argued for the question of remittal also said that, well, one doesn't know how much needs to be repaid, and there are all sorts of problems with calculations and the like. None of that was in the papers before the court. There was not a word in the papers before the court on why the repayment relief is problematic. There's a big difference between the repayment relief being granted in the terms that it is and implementing it. Once it gets implemented, one determines what those things are and they get paid. There's no difficulty in that. There's no problem in having those differences calculated. And if they say we made a mistake, then we made a mistake. But the order is you're entitled to the difference. As far as the delay point is concerned and whether it could be raised or not, it is correct that Mostert is authority for the half concession that I was aiming at, which is that if it is clear from the papers, if I'm challenging Regulatory Act A, and Regulatory Act A undeniably that I am challenging happened more than 180 days before my challenge, I should say something about it. And in that case, if I don't, one could take that point legally without having to raise it in the papers. If, however, you have the situation which is here, which is I challenge something, as Justice Theron rightly pointed out, I challenge the amendment regulations. I'm not interested in the old regulations. You come and you say, no, but you should have been challenging something else. And for these reasons, you should have been challenging something else. Then in that situation, that you cannot be in a situation where that point can appear from the papers and it can't be taken in argument. Our learned friend, I heard her to say, and I'm not sure whether she did so deliberately, but she said that the current application was in fact brought outside of the 180-day period, even from the date of the amendment regulations. And that, with respect, is not the case. It's never been the case. It's the first time that I hear that is suggested. The amendment regulations came out on the 23rd and 24th of January 2020. And on the 20th of July 2020, the application was brought, so it was within the 180 days. As for the question of repayment and the issues that were canvassed in that regard by Justice Theron with our learned friend, again, none of that is in the papers. There's nothing in the papers to suggest there's anything wrong with the repayment. And the attitude adopted before the High Court by the MEC was, we understand on Shuttleworth, it's correct that if this regulation stands to be set aside, then the repayment relief must flow. I may just point out that it's difficult to conceive of a reason why a tax that is levied unlawfully should not be repaid when paid under protest, which was the case also in Shuttleworth, and why it would have been regarded by the Supreme Court of Appeal as to have been perfectly fair on National Treasury in Shuttleworth for that repayment to be directed, and why it would then not be fair on the provincial government to have that repayment directed, particularly since it's only the repayment in relation to the difference. Those are our submissions in reply. And if there are any further questions in that regard, I think I'm well within the 10-minute period. Then I would field those questions, Chief Justice.
Thank you very much, Mrs. Snickers. I don't see any indication from colleagues that anybody has a question. That being the case, I think that therefore we have come to the end of the hearing. We are going to reserve judgment, and as soon as judgment is ready, parties will be notified as to when it will be handed down. Judgment is reserved and the court adjourns.
As the court pleases.